7 additional shots with a rifle. Accused number 2 on the video footage is then seen approaching accused number 1 after accused number 1 fired these shots. Thereafter, accused number 1 joined the delegates on the stage and was no longer in possession of such a rifle. The charges relating to this incident, Bishop, last night I must confess that I've read through the heads of counsel for accused number 1 relating to the charges that was proffered and the one that is in the state's heads of argument. I thought I might have omitted or made a mistake relating to the actual charges, as I wasn't around East London at the time when I asked the SPP, Senior Public Prosecutor of East London, to forward me or supply me with a copy of the charge sheet. It was with great difficulty that he managed to obtain, but only the magistrate or the district court charge sheet, which I thought might have been incorrect. I confirm that the charges as stated according to the charges in the heads of argument is correct. I confirm that. I will deal with the issue relating to what has been averred by counsel for accused number 1 in his argument or in his heads of argument relating to this particular issue at a later stage. The charges as per the charge sheet is unlawful possession of firearm to wit a .223 Norinco rifle and or a firearm, the make and model of the firearm owned and unknown to the state without holding a license or permit or authorization issued in terms of the act to possess such firearm. Count 2 is unlawful possession of ammunition. Count 3, discharge of a firearm in a public place or built up area or any part. Count 4, failure to take reasonable precautions to avoid danger to a person or property. Reckless endangerment to a person or property. Count 6 is providing a firearm and ammunition to any person not allowed to possess it. Counts 1, 2, 3, and 4 relates to accused number 1. Counts 4 relates to accused number 2. And count 6 also relates to accused number 2. Count 5 also relates to accused number 2. Use of just the background, the state have called several witnesses which is listed in the heads of argument. I'm not going to go through each and every of the witnesses' evidence. It seems to be common causes relating to what the state witnesses have testified. The background of this particular matter is that at some point a section 174 application was brought for the discharge of the both accused. It was opposed, and then the application was then unsuccessful. Consequently, the accused had to present their case. What is of importance in this particular matter is that 7.1 of the factual matrix is the evidence of Colonel Ngamlana Mkwali, who's a member of the South African Police Service, who testified that he was appointed in terms of the Safety and Sports Recreational Event Act 2 of 2010 on the date of the incident and was sitting in the Bok area of the stadium. He testified there was no prior discussion with him or any other member present that shootings will be conducted with weapons or that such a simulation of such shootings would occur, and nor was such permission ever granted by him. According to him, he heard a noise on the night in question, but he did not see accused number 1 or accused number 2 firing any shots on the date of the incident. He testified that on 30 July 2018, he received a viral video footage on his cell phone depicting accused number 1 firing shots with a rifle on the stage, and was obligated to open a case docket or inquiry to initiate the investigation into the incident. The second witness that also testified, evidence is also of importance, is Ntombi Fikile Mankomo, who testified that on the 30th of July 2018, she was employed by Buffalo City municipality to clean up the stadium after the EFF's birthday celebration had taken place, and found an empty spent cartridge on the right-hand side of the stadium, which was a few meters away from where the EFF stage was erected on the 28th of July 2018. She told her supervisor, Nomfundo Luana, as well as Mr. Jonathan Kumalo, an assistant manager with the disaster management at BCM. Mr. Kumalo advised her to hand the cartridge case to Luana, her supervisor, which she did. Captain Swart visited the stadium on the 1st of August 2018 to interview this witness regarding the discovery of the spent cartridge case. She informed him that she gave the cartridge case to Luana, who is her supervisor. She was also requested to point out the location where the cartridge was retrieved. Sergeant Tuze took photos when she pointed out the place where the cartridge case was found, and this photo album was also handed in as an exhibit. Mr. Fundo Luana basically confirmed the background as to how this cartridge case was retrieved, or how she handed this spent cartridge case over to Captain Swart. Mr. Kumalo confirms that he was informed by the witness which I just mentioned, Ms. Mankomo, about the spent cartridge case. He was also at the stadium on the 28th of July 2018 when the incident occurred, but also said that he also heard just cracking sounds just before EFF's event came to an end. He was unable to say whether it was gunshots or whether it was indeed the fireworks which he observed being displayed at the end of the event. Captain Gerardus Swart's evidence is a member who stationed at Ndansane. Basically, he testified how he interviewed Ms. Mankomo and Ms. Luana, and they confirmed the discovery of the spent cartridge case. He put it in an evidence collection bag which is sealed with the evidence number, bag number, being referred in the heads of argument. He took that bag and placed it in the SAP 13 register with SAP 13 register 699 of 2018. Colonel David Jansen is a member of the South African Police Station service station at the firearm and liquor section of SAPS. He testified that on 3 August he performed a compliance inspection at Tactical Security Providers, the business premises where accused number 2 is a manager. Mr. Mdluli, the co-owner of the business, was not present according to him. Accused number 2 was at the premises and granted them permission to inspect the main firearms register where all the firearms of the business were recorded. On the same day, 2 firearms, a .223 Norinco SPA 249, which is the firearm in question in this particular incident, which the accused is being charged for, that was booked out to Larry Mabuntla, and a 9mm P Glock handgun were presented for inspection. Accused number 2 informed this witness that he knew that the members of the SAPS would require these specific 2 firearms for ballistic testing. This witness did, however, not take possession of these weapons, just made an entry in his register for his record, more specifically regarding the conversation between him and accused number 2. Sidney Henry Standard testified that he is a regional manager with a private regulatory authority, inspected the records of the security company of accused number 2's business, or where it's alleged that accused number 2 is a manager, and confirmed that accused number 2 was at some point registered as the owner of the business, and this business was at that stage also co-owned by Mr. Mdluli. He testified further that accused number 2 had all the required licenses to handle shotguns, handguns and rifles. Testified accused number 1 had the license to possess a 9mm firearm, but his competency certificate has expired in 2016. Warrant Officer Philip Becker, a member of the South African Police Service attached to the Provincial Crime Scene Investigation Unit of the SAPS in Gqeberha, testified that on 3 August 2023 he drove to East London to collect the spent cartridge in question, which was found at the Sisaku Dukasha Stadium after the incident. That he collected from the Mdansane SCP-13 storage facility. He took it to the lab and swapped it for touch DNA as well as fingerprints. He found fingerprints on the spent cartridge, but both accused fingerprints were excluded on the spent cartridge that he found. He resealed the cartridge case and handed it in for further tests to be conducted by the ballistic unit. Of importance, these evidence were then tested by Lieutenant Colonel Mandisa Ngwadleka, a member of the African Police Service attached to the ballistic section in Gqeberha. He testified that on 2 August 2018, he received the spent cartridge and performed several tests on it for comparison and found 3 identifiable marks at the neck area of the cartridge case. He also received several firearms which were sealed in evidence bags. On 17 August 2018, they received another batch of firearms which included the .223 Norinco SPA 249-14 rifle. This is the rifle we are referring to, of which the accused is charged for. He compared this rifle with the spent cartridge case that was collected at the scene through microscopic examination and found that this firearm was positively linked to the cartridge case. He concluded that the spent cartridge case was fired from the .223 Norinco SCP 249-14 semi-automatic rifle. He also noticed that the serial numbers of the breech block consisting, the breech block, I'm going to get to that point when I argue later, the breech block consisting of the firing pin, the breech face, extractor, and the ejector, and that this did not correspond with the rest of the serial numbers of the firearm, and concluded that it was changed to affect the outcome of the ballistic test. But despite these changes to the breech block, he was still able to find sufficient markings on the cartridge case and the chamber of SPA 249 to conclude that it was indeed fired from the said firearm. The firearm and the cartridge case were presented at court, and the defense expert was provided with an opportunity to examine the exhibit under the supervision of Colonel Ngwadleka. Colonel Ngwadleka confirmed that the markings that are made on the cartridge case by the firing pin, breech face, extractor, and ejector were negative as these parts form part of the breech block that were removed after the shots were fired, but before the firearms were sent to the ballistic unit for ballistic tests to be conducted. The evidence of Mr. Ngwandleka was thoroughly tested by the defense, and it's my submission that it remained unshaken and it remained consistent. Yusuf, if I can just rush through the evidence of Ashley Singh, Samuel Kwata, and Sibusiso Ngobo. Those are the employees of the house that was contracted to do, it was hired for the stage equipment, the lighting, the power, the video equipment, as well as for this 5th birthday celebrations in East London. Basically what they did, 204 subpoena had to be issued when the police visited, as they were not willing at that point to hand over the video footage that was recorded relating to this particular incident. Mr. Ashley Singh is the manager, but he was not present at the time. He testified that he also possesses a license to have a firearm. He testified what he observed with Samuel Kwata and everybody else when the police visited their offices in KZN in order to collect these video footages, these recordings. They saw accused number 1 firing shots, several shots with 2 different caliber firearms during the EFF's celebrations. Samuel Kwata, Sibusiso, and Ngobo were present. They were the ones that operated this particular video equipment. They confirmed what they've seen on the video footage after the police visited, but according to the 2 of them, while they were there, they did not see accused number 1 firing any shots because they did leave the video footage or the video equipment unattended at some point. Worship, I'm going to the evidence of Colonel Nkosiko Nzuku, who's also employed as a media liaison officer, and testified that on 1st August 2018 he received a viral video footage depicting accused number 1 firing shots at the EFF's 1st birthday celebrations from Captain Juan Sandari, governor, who worked at the SPS provincial office in Bishop. He also observed the video footage that accused number 1, according to him, handed the firearm over to accused number 2 after he fired shots. He forwarded the viral video footage to the investigating officer, Colonel Rodney Swartboy. Colonel Swartboy then requested him to compile a report from all media coverages relating to this particular incident, which he did. Good Howders, good Matthews counsel for Kinaman put it to the witness under cross-examination. It was a toy or blank firearm. This witness testified that he observed muzzle flash emanating from the firearm, and in his experience that real firearms is the ones that fires or has this type of muzzle flash when it being fired. A warrant officer, Amanda Yvonne Steenkamp, is also a facial expert at the SAPS. On the 2nd of August, she received a sealed CD containing still photos of the viral footage from Colonel Swartboy and was requested to compare the images on the still photos with social media images of accused number 1 and accused number 2. She was able to see from the photos accused number 1 firing shots with a rifle and thereafter handing the rifle to accused number 2. She was able to identify the muzzle flash but confirmed that she was unable to confirm whether the firearms were indeed real or not. She positively identified the persons depicted on the still photos as accused number 1 and accused number 2. Bishop Sergeant Dwayne Francis, a member of the SAPS employed at the Digital Forensics section of the SAPS here in East London, testified that on the 1st of August 2018 he received an official handset from Colonel Swartboy and was requested to download the 2 viral videos from the handset. He thereafter downloaded it on a CD which is sealed. A copy of the CD was then handed to the investigating officer and the second copy to Captain Rian Buerta. He did not tamper with the video footage while it was in his possession. Captain Rian Buerta also confirmed, is attached to the Digital Forensic section of the SAPS, testified that the following day, the 2nd of August 2018, he received a sealed CD containing the viral video footage and was requested by Colonel Swartboy to make still photos to be sent for facial comparison and identification. He was able to see from the footage how accused number 1 fired several shots with a rifle and thereafter handing the rifle to accused number 2. He noticed the muzzle flash but confirmed that he was unable to confirm the firearm whether it was real or not. He did not tamper with the video footage while it was in his possession. Then we deal with the evidence of Captain Governor Muan Sandari, who was employed at the SAPS as a media liaison officer in Bishop. She testified that on 1st August 2018 she received the viral video footage depicting accused number 1 firing shots at the EFF's first birthday celebrations from the national media database of the SAPS. She also observed accused number 1 firing several shots with a rifle and handing the firearm to accused number 2 after he was done. She forwarded the viral video footage to Colonel Mzuka and requested him to investigate the matter further. She also identified the muzzle flash of the firearm when the shots were fired. Under cross-examination, this witness was unable to state whether this was also a toy or blank a movie firearm. This witness tested that she observed also muzzle flash emanating from the firearm, and in her experience that real firearms have muzzle flash when being fired. Colonel Swartboy, basically, you worship the evidence of Colonel Swartboy, it was basically just to complete the chain regarding to the investigation and the collection of the firearm in dispute SPA, the 2.23 Norinco firearm, 223 Norinco firearm. He gave a background, what happened during the investigation and how the investigation led to the matter being brought to court. The only aspect about his evidence, how he collected the batch of firearms, which included this particular firearm, SPA 249. And that all these firearms were sealed when he received it at the Brighton Beach Police Station in KwaZulu-Natal. He was also responsible for taking these firearms to the ballistic section of the Forensic Science Laboratory in Gqeberha. Swartboy testified that he did not tamper with any of the exhibits that included the video footages, the cartridge case, the Norinco firearm, while it was in his possession. Much was made about the fact that Colonel Swartboy did not testify regarding the fact that the members of the SAPS that was employed as close protectors of accused number 1 stated that they did not see accused number 1 firing shots on the day of the incident. Bishop submitted that all these witnesses that testified were good, honest, credible, and reliable witnesses. They did not go out of their way to falsely implicate any of the accused before court. The evidence were objective. that is basically my submission regarding their evidence. Your Worship, I'm going to deal with the evidence in the manner in which it was led in court, starting with the evidence of accused number 2. We know accused number 2 did not testify and elected or utilized his right to remain silent. He did, however, call witnesses to testify on his behalf. Yes, when I start with the accused number 2, to start off, I already conceded that the viral video footage relating to the transfer or the handing over of the firearm by accused number 1 to accused number 2, I will concede that that is not clear. As an officer of this court, Your Worship, my job is not to secure a conviction at all costs. My job is to assist the court to come to the correct decision. Accused number 2, when I took a closer look again at the viral video, reveals how accused number 2 was just a shock from my perspective. I might be wrong, Your Worship. That's my submission. It looks like he was just a shock when accused number 1 fired these shots. To me, he seemed unaware and caught off guard when he appeared quickly to take the rifle from accused number 1. It is my submission relating to accused number 2 that the state has not proved its case relating to that particular aspect beyond reasonable doubt. This submission is made after proper consideration of the evidence relating to the third video, which is referred to as the viral footage, coupled with the submissions made in the state's further particulars. Your Worship, I suppose I didn't draft the further particulars, but I had sight to that particular further particulars. We are bound by such further particulars, wherein it was alleged that accused number 2 handed the rifle to accused number 1. My submission relating to this particular aspect, that the video footage is inconclusive in this regard. Bishop, after making such a submission, just for the completeness of the record, I need to comment on the evidence of accused number 2's witnesses for the sake of completeness, as the ballistic expert testified in the presentation or during the presentation of accused number 2's case. If I can deal with the first witness that was called by accused number 1. Your Worship, I'm only doing this for the sake of the completeness of the record. Martin Hood is a practicing attorney that's common cause amongst the parties that provides legal advice to security companies regarding firearm related issues. Your Worship, in my view, this witness testified and interpreted the provisions of section 120, subsection 10, in brackets A, of the Firearms Control Act of 2000, which reads as follows: it is an offense to sell, supply, or in any manner give possession of a firearm or ammunition to a person who is not allowed in terms of the act to possess such firearm or ammunition. The witness also had to go or testified about the provisions of the Regulation 2021 and 2022 of the Firearms Control Act. The regulation in paragraph 15 relating to Regulation 21, which states that any person working with a company firearm who possesses the qualifications to use any gun for business purposes has to undergo constant assessment every year. And Section 22 of the Firearm Control Act deal with the holder of a license may allow another person to use a firearm, and states as follows: despite anything to the contrary in this act, but subject to Section 120, subsection 5, any person who is at least 21 years of age and the holder of a license to possess a firearm issued in terms of this act may allow any other person to use that firearm while under his or her immediate supervision. It is submitted that the evidence of this witness, in my view, it's irrelevant and of no value for this court, because it's the court's duty to interpret legislation. And Bishop, I can refer the court to this particular matter of the Director of Public Prosecutions, KZN versus Matiani, where versus P. Matiani, JR, remarked at paragraph 7 as follows: courts do not need professors of law to tell them what the law is or the law should be. Why this particular witness has been called, it's still a mystery to me. Any opinion, whether expert or non-expert, which is expressed on an issue which is the court can decide without receiving such opinion, is in principle inadmissible because it being irrelevant. In that regard, I want to refer the court, see State S versus H. And also refer the court to S versus Nell. The footnotes are related to the citation is down at the footnotes. In S versus L, it was found that in such an instance the opinion of a witness excluded not because of a need to preserve or protect the fact-finding duty of the court, but because such evidence makes no probative contribution, creates the risk of confusion on the main issues, and can open an evidential Pandora's box. It was also clear, this witness didn't have insight into the facts. He didn't even know what transpired, why he came to testify. It's still a mystery. I would go so far as to say the court can actually strike his evidence from the record unless the court is convinced otherwise. I want to refer the court to paragraph 14. The general rule in South Africa is that the opinion evidenced by witnesses is not admissible. It is irrelevant because it is the function of the court to draw inference and form its opinion from facts. The witness gives evidence as to the facts. The court forms its opinion from those facts. This is just a confirmation of my previous submission that I've just made, that this witness didn't have any insight as to relating to the facts. He didn't know what was going on. Maybe he was called to testify to confirm that the accused is competent to basically possess a firearm relating to accused number 2. So an issue that is not in dispute. We know he has all the required licenses. He's not being charged for that offense. I've already read the evidence relating to Section 22 and Regulation 21, what it states, but it's admitted that accused number 2, in his own evidence of this Mr. Wood, if he had insight into the facts and what had transpired from his own evidence, accused number 2, if you look at section 120(10)(a), would have been guilty of an offense if the state had proved that he did indeed, if I didn't make that concession earlier, that the evidence is inconclusive of accused number 2 actually handing the firearm over to accused number 1. If I was able to prove that accused number 2 would have been convicted of a particular offense, if you look at section 120(10) in brackets A. Insofar as accused number 2 is concerned, I've already made my concession relating to him, and that I did not prove the case beyond reasonable doubt, and that the video relating to him handing the firearm over to accused number 1 or vice versa is inconclusive. But I'm obliged as an officer of this court to direct the court of the provisions of section 257 of the Criminal Procedure Act if this court is not in accord with the state's assessment of the evidence insofar as accused number 2 is concerned. Despite my concession, Your Worship, you might find otherwise, that you might not agree what I have just conceded relating to accused number 2. That's why this provision will become important, and it's my duty to assist the court to look at this provision. The section reads as follows: if the evidence in criminal proceedings does not prove the commission of the offense charged, but prove that the accused is guilty of an accessory after that offense, or any other offense of which he may be convicted on the offense charged. I want to repeat that again, because I think accused counsel for accused number 2 and myself will have a disagreement only on this particular part. That is the decision where the court had to make a particular finding. If the evidence in criminal proceedings does not prove the commission of the offense charged, but prove that the accused is guilty of an accessory after that offense, or any other offense of which he may be convicted on the offense charged, the accused may be found guilty as an accessory after the offense, or as the case may be, such other offense, and shall, in the absence of any other punishment expressly provided by law, be liable to punishment at the discretion of the court, provided that such punishment shall not exceed the punishment which may be imposed in respect of the offense with reference to which the accused is convicted as an accessory. On that particular point, it's quite a mouthful relating to that particular section, what it says, and so on. My interpretation of the section is that the accused may even be charged for the offenses which was committed by accused number 1 if he is an accessory after the fact of that particular offense. Your Worship, insofar as that is concerned, I think that is where the issue is between me and counsel for accused number 2, and that's a finding which the court will have to make relating to the interpretation of that particular section. My reasoning for that is an accused is not always present, or an accused may not have been present at a particular murder scene where a murder was committed, but his colleagues may come afterwards, ask him to assist him to bury the body or do anything else after that. That is actually what this particular section is referring to. In fact, that is my submission relating to that particular section, Your Worship. That is for the court to interpret that particular section, as the court's duty is to interpret the legislation. Snyman's criminal law states as follows: a person is an accessory after the fact to the commission of the crime if after the completion of a crime he unlawfully intentionally engages in conduct intended to enable the perpetrator of or the accomplice in the crime to evade liability for his crime, or to facilitate such a person's evasion of liability. It is submitted that accused number 2, in my view, my submission in this regard is that he's the only one that could have removed that bridge block and or facilitated the removal of the bridge block of SPA 24940 to affect the outcome of the ballistic test results. I will engage Your Worship later on in relating to this submission that I've just made in the following up paragraphs that are. Your Worship, the analysis of the evidence between the two ballistic experts, as Your Worship is aware that not much is in dispute between counsel for accused 1 and 2 and the state. Most of the evidence between us is common cause. The only issue that is really in dispute is whether the firearm that was fired on the 28th of July 2018 was indeed a real firearm or whether it was a toy or movie gun as submitted by counsel for accused number 1. Therefore, the importance of this evidence relies basically in the evidence of the two ballistic experts when it comes to this particular issue. Usually, I want to deal with the evidence insofar as accused number 2's witness, Jan Stoffel de Klerk, and the evidence of Mandisa Ngwadleka. Firstly, let me start off with Mr. de Klerk, the evidence of Jan de Klerk. He did not personally examine the firearm itself and test it against the spent cartridge found on the scene. That's the first and an important point. It's submitted that the evidence of de Klerk cannot be taken seriously and should be disregarded and rejected by this court on that aspect alone. The Klerk evidence is merely an opinion and relates to the photographs of the core chart and the inspection of the spent cartridge case. This core chart was then compiled and explained and illustrated to court by Colonel Ngwadleka to show the court how he positively linked the spent cartridge case to the firearm or the rifle referred to as SPA 249. Ngwadleka testified, as I've already alluded to, that he received the batch of firearms which included this particular firearm. He performed several tests on these firearms SPA was the only firearm whose breech block and firing pin serial numbers did not correspond with the rest of the serial numbers of on the firearm. So in other words, from all those firearms, 14, 12, 14, if my memory serves me correctly, Your Worship, I stand to be corrected. It's 28. It's about 40 of those rifles that which he examined, or the firearms that he examined, and this from that 40 is the only rifle that whose parts were changed. It's no coincidence that that breech block was removed, because it seems to be important when it comes to the rest of the spent cartridge and to how positive tests would have been conducted or how a positive finding would have been received. How do you make a mistake from almost 40 firearms and you only one of those, the one who's been linked positively to this offense? I submit that, to me, in my view, that's no coincidence. It's been done deliberately so to affect the outcome of the ballistic test. Colonel Guadeka found 3 markings at the neck area of the cartridge case that corresponded with the markings in the chamber or the barrel of SPA. The reason, therefore, he testified that that is part of the firearm, and it will be very difficult to change that barrel of a particular firearm. That's why he looked at the neck area. You need special equipment to actually take off that particular barrel and remove it from a firearm. It is submitted that the evidence of Colonel Guadaleka was not seriously contested. It was seriously contested, but it remains still unshaken. Thank you. Your Worship, insofar as the issue relating to the removal of this particular breech block, it was conceded by counsel for accused number 2 when I went through the record in that aspect, that it was not disputed that it was indeed changed, the breech block. Whether it's by mistake or not, that was done. And I will refer the court to the particular page number in the record where I've marked it. I just don't want to rush through my things now. I will do it at a later stage before I end off my argument. I have been placed in possession of some portions of the record. It's not a complete record, Your Worship, but most of the record is with me. This record was also forwarded to counsel for accused number 1 and accused number 2, but not directly to them, but to the instructing attorneys. The clerk examined the spare cartridge case by taking photos of the cartridge case with his cell phone. He did not perform any microscopic examination on either SPA 249 nor the spent cartridge case, and considered that the manner he used to conduct this examination was not an acceptable method to be used, nor is it standard practice for ballistic experts. The clerk considered that Colonel Guadaleka's approach would be more accurate than his. The clerk further considered that he had last completed a proficiency test when he was still employed by the SCPS. We all know that he left in 1989. He was employed since 1980, if my memory serves me correctly, until 1989, either 1982 until 1989. I just need to go through again, to give the court an accurate. The clerk considered that about this competency test, the proficiency test, when it was last, which we know now, it's almost 30 years or more than 30 years ago, 1989. The clerk referred to an ejection port method, which is ejection port mark, which he observed on the spent cartridge, but conceded that the mere presence of this mark does not mean there is a positive result. It needs an individual characteristics in that particular mark, according to Colonel Ngwadleka's evidence. Those markings relating to the firing pin and all that, which Ngwadleka found to be negative, is consistent with that bridge block because it consists all those parts. Obviously, the test result would become negative relating to the firing pin. If I can just go back. I did mention the part that's actually part of the bridge block. In paragraph 3 of the clerk's report, he states that he examined more than 3,950 forensic related cases, but it became clear under cross-examination that the clerk has inflated in his experience insofar as the number of actual ballistic tests performed by him. He also considered that no peer review was done to confirm the veracity of his findings in the report, where Colonel Ngwadleka had 2 other people peer reviewing him. That was the evidence of Colonel Ngwadleka. Not only one, but 2 other peer reviewed his findings. What I also found strange about the clerk's evidence was we had another expert right next to him who's been attending this court from the beginning of this court proceedings. Yet he went to go to Stale, who's in the United States of America, to look at his ballistic results. I find that to be improbable. My submission in that regard is that it's improbable that you would rather send it so far, but you had somebody who's been walking the road with you right from the get-go. The clerk inflated his experience of the number of ballistic tests. He couldn't give the court the number. He also considered about the peer review to confirm the veracity of his findings. To me, it's still uncertain why he made a video to demonstrate the muscle test, as it does not take the accused case anywhere, since he was not sure whether the blank firearm presented in court, the one that was presented in court, was the same blank firearm that he used to make the video. He confirmed that the 3 markings in Colonel Ngwadleka's report were sufficient, but to make a positive finding, I did not dispute Ngwadleka's positive finding much in that regard. He was referring to that dent that you see, which Ngwadleka confirmed there is such a mark, the ejection port mark, which was visible with the naked eye. But Ngwadleka said he examined it, but there were not individual characteristics to make a positive or a negative finding in that regard. This indicates clearly about the objectiveness of Ngwadleka's evidence in this regard. The clerk was employed as a captain in 1989 when he resigned with only 9 years experience in the employ of the SCPS, and has far less experience than Colonel Ngwadleka, not only in rank but also in experience. He had less experience than Colonel Godlek in performing ballistic tests on actual crime scene exhibits, as well as the comparing of spent cartridge cases with firearms of actual crime scenes. He considered that opportunities in performing ballistic tests with actual crime scenes exhibits are rare and almost non-existent if one is employed in the private sector and when a person is self-employed. Just on that 9 years experience of the clerk as a captain, there's many ranks between the captain from constable, in those days sergeant, I think inspector or warrant officer, lieutenant, yes, lieutenant, and then you will become a captain. So he, between 1980 and 1989, if my math served me correctly, he at least spent 1 year in a particular rank if my math is correct. I see council made a submission that just because somebody's been driving more to a council for accused number 2 have driven more than driven a motor vehicle more than the other one doesn't mean that person is a better driver. The jury will be out on that one. Whether you would rather trust a person who has been driven a vehicle to different places so many times than the one who has driven far less than the other insofar as experience driving. I also think that submission in relating to that is not relevant to this particular issue. If the clerk testified that Godleka should have done more by also inspecting the chamber of the firearm and comparing it with the cartridge case. This issue was canvassed by Godleka under cross-examination, and it became apparent that he did do the requisite investigating by examining the chamber, the barrel of SPA 249 rifle, and compared it with the neck area of the cartridge case before he concluded with absolute certainty that this spent cartridge was fired from SPA 249. It is submitted that the court can safely reject the clerk's evidence where it is inconsistent with the findings of Colonel Godleka. Colonel Godleka's evidence has been consistent and reliable in all material respects when compared to that of the clerk. In fact, Mr. de Klerk was a horrible witness, to say the least, Your Worship. Godleka performed 4,724 actual crime scene ballistics tests that was in 2018, which is at least 776 more tests performed by the clerk, if my math is correct. You tell me, would you rather prefer to drive with somebody who has driven 700 times more than the one who has far less experience than that? Your Worship, ballistic experts in Godleka and the clerk were not provided with an opportunity to examine and comment and or give an expert opinion on the blank or the brand new rifle that was produced by accused number 1 right at the end of the trial. Moreover, to express an opinion as experts on whether that blank firearm is the same or similar or resembles the rifle in the video footage. It is submitted that this was done is a desperate attempt to create doubt in the mind of the court. Further, it's also submitted that that type of, it's common course by the experts that blank firearms do not produce real spent cartridge cases, such as the cartridge case that was linked to SPA 249. use of the blank firearm or the toy firearm was the basis of accused number one's defense, and one would have expected that it should have been produced to the ballistic expert, at least to their own ballistic expert, to compare it with the video footage and give an expert opinion on this aspect. In my view, the evidence relating to the actual blank toy rifle and the timing of presenting such evidence does not bolster the accused defense, nor does it take the case anywhere. Mr. Clerk testified that he was not sure if the blank rifle he used to demonstrate muzzle flash was indeed the same rifle that was produced in court by accused number one or during his evidence in chief. Even if it was the same firearm, it will be a clear contradiction of accused number one's evidence when he testified that the blank or toy rifle belongs to the EFF. The clerk testified that the blank toy rifle was sent to perform tests on it by accused number two. He rectified his evidence in this regard and stated that he was provided with the blank toy rifle by Tactical Security Company. So if that is the EFF's firearm, why is it being produced by Tactical Security Company? If that is a firearm that can be used, why it had to be brought to court on that particular day by somebody with the expertise to have such a particular firearm in his hand. The way it was presented leaves much to desire. The evidence of accused number one, let me deal with that. Accused number one testified and confirmed that he was at the stadium. Like I said, it's not in dispute. But he said he was there the day before, on 27 July 2018, before the incident, to inspect the stadium, and he saw accused number two also being in attendance, but is unable to state why accused number two was present at the stadium. We know why. It's in accused number two's, counsel for accused number two's head, that he was employed there to provide security services. That he was being escorted from the airport by 4 bodyguards which were in the employ of the SAPS VIP Close Protection Unit. These bodyguards were with him even when he wanted to use the bathroom. The event of the EFF's first birthday was on 28 July. He arrived at the State Sisa Dukasha Stadium at 1 o'clock, 1300 hours on the day of the incident, and walked amongst the attendees for a meet and greet, as it would be very difficult for him to do so once he was on stage. There were approximately 20,000 people attending the event, which consisted of the EFF's delegates and supporters, members of SAPS, medical and security personnel, as well as the media. Different artists performed on stage. He gave a speech at approximately 1400 hours where he addressed his supporters. He confirmed that the members of the Joint Operational Center, which included Colonel Mkwali, were also present and were responsible for approving every little thing that happened on the stadium. He confirmed that he had no prior approval, or he did not obtain any prior approval for Colonel Mkwali or any other member of the Joint Operational Center for a simulation or a discharge or discharging of firearms. He denied that he possessed, used or discharged firearms or lawfully, or fired shots in a built-up area, nor did he endanger the safety and lives of others. He testified that SAPS would have reacted by arresting him and would have recorded such incident in their pocketbooks if an offense was committed by him in their presence. He further testified that nobody who attended the event complained or laid a criminal case against him and no witnesses came forward to testify that he unlawfully used a firearm by discharging it, and states that this case is politically motivated by Afrikaner. It has already been submitted previously, which the Colonel Kwali is the one that actually laid the complaint that had to be investigated. Much is also being made by the fact that none of the attendees actually raised a complaint or laid a charge. If you drive your vehicle under the influence of alcohol and intoxicated, just because you did not get arrested on the night in question does not mean that you did not commit an offense. He denied he identified several of the EFF delegates that were on the stage with him and stated that none of them made a criminal complaint because they were possibly or might have been scared of him. He knew accused 2 since 2008 and met him after he gave a speech at the University of KwaZulu-Natal. According to him, the university experienced load shedding during his speech. He was then taken away from the university premises as this posed a security risk, and he found himself in a BMW driven by accused number 2. He stated that he was petrified being in a vehicle driven at high speed with a white man. He testified that the firing of shots that was planned, or the firing of shots were planned prior to the event to wow the crowd and to keep them entertained so that the attendees don't feel bored. He states that accused number 2 did not give him any firearms on the night in question, and that the rifle was handed to him by Larry Mavundla, who's also an employer at Tactical Security. Accused 2 did nothing wrong, according to him, during the incident, and was only being charged because the state hoped that accused number 2 would turn him as state witness against accused number 1. That concession is not true. We don't charge people in hope that the one would turn against the other one. That's just not how we conduct our business. He produced a rifle in court and testified that the rifle just looked like it was real, but was indeed the blank rifle that belonged to the EFF. He states that the investigating officer, Colonel Swartboy, never approached him during the investigation to request his firearm, as it could have been his firearm that he used during the incident. Accused 1 states that he knows firearms and has been trained by the African National Congress how to handle firearms since the age of 9 as an anti-apartheid activist. He legally owned a firearm since the age of 19 when he was still a minor, and as the ANC had to request permission for accused number 1 to possess a firearm, which he keeps locked in his safe. Accused number 1 counted the shots during cross-examination and counted 20 shots being fired with a particular handgun. To evaluate accused number 1's evidence, Your Worship, he contradicted himself in so many ways. He contradicted his evidence when he testified that everything had to go through the command center, yet no discussion or approval was obtained from Colonel Nkwali about the shooting or anybody else present. Accused 1 testified that 4 bodyguards were assigned to him. It never left him alone even when he attended the bathroom, since they were there to protect his body and were responsible for his safety. In cross-examination, he adjusted this version and was unable to say where all the bodyguards were during the incident, only identified 2 of the bodyguards on the video footage. The sworn statement of the 2 of the bodyguards stated that they were never inside the stadium during the incident and were stationed behind the stadium. Accused number 1 did not dispute this aspect. He contradicts his evidence in chief that all 4 bodyguards guarded him and were present during the incident. If his version in this regard is to be accepted, the conclusion would be that all the bodyguards lied about being on stage during the incident, or that they were not forthcoming about what they witnessed, as this shooting incident is common cause between the state and the accused. There's no dispute about it. It did happen between the parties. He was untruthful about knowing what a 9mm handgun looked like when questioned what type of firearm he fired in the first video during the incident. His evidence in this regard cannot be true, as he owns a 9mm Taurus handgun and received training, according to his evidence, by the ANC regarding the handling of different firearms since the age of 9. I see there's a typo. I typed 19. That can just be amended to 9 years. He lied about seeing people running after he fired the shots, despite this factor being and so obvious, as people could clearly see being seen running in the first video footage when he started to discharge the 9mm Glock handgun. It's our submission that that handgun was indeed the Glock that was produced when Colonel Janssen went to Tactical Security Services the first time that he went there. He lied about things that were so obvious about the number of shots being fired with a handgun, despite both experts counting 14, 15, around 14 and 15 shots being fired, and an additional 7 shots with the SPA 249. Accused 1 was provided with an tube to count these shots from the handgun in the first video. He counted 20 shots being fired, and when probed how he got to 20 shots, he stated that he did not do accounting at school, but would work as a subject. He refused to answer more questions on this aspect and stated that he was not being charged for discharging a handgun and will only answer questions relating to the discharge of the rifle. It was clear that he was evasive and prepared to adapt his evidence as he anticipated the state's cross-examination on this issue. The state will argue that the 15 shots that were fired with that handgun are exactly the number of shots that are being discharged by a real 9mm Glock P standard handgun with a fully loaded magazine, as per the evidence of a ballistic expert. He was untruthful about knowing in which capacity accused number 2 attended the event, and stated that he had no knowledge why accused number 2 was there during the incident. This is clearly a lie and contradicts his evidence regarding how and under what circumstances he met accused number 2 in 2008 at the University of KwaZulu-Natal. Accused number 1 realized that what dangers accused number 2's presence as a bodyguard on the stage posed to his defense, as his version in this regard would become highly improbable that accused number 2 and or Larry Mavuntla would guard him using blank toy firearms. He testified in his evidence in chief that the EFF decided to use firearms in the celebration and conceded that this was not discussed with any of the persons who were responsible at the event of the Operational Command Center. He was unable to give a satisfactory explanation why this issue was not discussed before its display and why this planned show ended up in becoming a sideshow, since he moved away to the far right of the stage to fire several shots in the direction where there were minimal, and from what I counted there were 7 people that were running away from that while he fired that shot. Unable to explain why he didn't just fire the shots towards the crowd. No, it's because he knew this was just a show and a toy firearm with no effect if he did fire it into the crowd of 28,000 attendees. It submitted that his version in this regard was fabricated, as this side show, which was ended up on the far right side end of the stage, defeats the whole purpose of accused number 1 or the EFF's decision to put up a show for the crowd. The show ended up there on the side. Accused number 1 became aggressive when probed on his conduct on this issue and responded by asking Ungenapi, meaning where do you enter, in how EFF conduct his business. This issue was an important issue relating to why he actually fired shots there. As I will later argue, if you look at the video, it was right at the end of the stage. His response when probed by that, he said, I can fire shots even from underneath the stage if I wanted to, and will not be told where to fire shots. There was no plausible explanation forthcoming for his conduct on this issue, and he answered this question with a rhetorical question. Accused number 1 seeks to enter into speculative explanation for conduct which, on the face of it, when you look at it, it's incriminating. He is much testified that he said, when you look at that, everything looks so real. It is clear from the evidence, when considering how and where he fired these shots, and the reaction of the 7 people in whose direction his shots were fired, that accused number 1 knew that these firearms were real, both of them, and that firing it into the crowd would pose a serious danger to the lives and limb if he had fired it directly to the crowd. The person handling the first firearm, remained behind accused number 1 while he was shooting, which is one of the most fundamental safety rules when handling a loaded firearm. Remain behind the shooter. And when you look at the video at first glance, the person that handed over the firearm to accused number 1 took it from him, and again after he fired shots, and pressed the slide to release it, as the slide remained backwards in a backward position when it's empty, when the magazine was empty, and was compelled to ensure that the slide would move forward in order for him to put it back at his back where he originally took it from. The fact of the matter is that shots were fired away from the masses assembled because of the serious danger it posed if he had fired it directly towards the crowd. The evidence clearly indicates that both firearms that were discharged on the day were real firearms, and the court should make such a finding. Accused number 1's biggest problem is the smallest piece of evidence that was presented, which is that spent cartridge case. Much has been made, Your Worship, as to where the spent cartridge was found in relation to where the actual stadium or stage was erected. I remember when I was doing my pupillage, we had this, an exercise that we had to do for the judges, Your Worship. And then the purpose of the exercise is what one vehicle, which is a BMW 7 Series with all the best features, were driving on the left-hand lane of the William Nicole Road. The other vehicle came from the different direction, drove next to the 7 Series BMW vehicle. The lady in the BMW vehicle was on her phone during this incident and didn't take much note of the other person driving next to her in a VW Polo. It happened so that the Polo wanted to move from the one side into the other side and veered into the BMW. When the paramedics came, the lady in the BMW was still looking for a phone and she said to the paramedic that she was still on her phone when this accident happened. So both parties, some have to appear for the plaintiffs, some have to appear for the defendants in the matter. We had to argue against on this point. Obviously, the defendants were now using the issue that she was on her phone during the incident and she didn't take much care of the fact that this person was veering into that particular vehicle. The answer to that, Your Worship, was the question from the judges at that point is, so what? So what if she was, even if the phone was in the air, it doesn't matter, she remained in her lane. The question to this, so what? This, where the spent cartridge was found, whether it was 5 meters, 10 meters, 15 meters, 20 meters. The point of it, it was found at that scene, at the stadium where the incident occurred, and our submission is in very close where the box or the stage was erected. It's in close proximity. It wasn't found outside the gate. It was found in close proximity where the stage was erected. Your Worship, the fact of the matter is that the shots were fired away from, and the shots were fired on that particular day with a real firearm. Your Worship, accused number one's evidence and answers during cross-examination were clearly an attempt to distract this court from this incriminating conduct as to what transpired on that particular day in question. Your Worship, accused number two, the court must also view the actions of accused number 2, whether it's this current present accused number 2 or the one that is referred to by accused number 1 as accused number 0, which we now know this accused number 0 is being referred to as Larry Mabunkla. The fact of the matter, both of these parties, whether it's accused number 2, if you look at the video, or this Larry Mabunkla, they remain behind accused number 1 when he fired those shots with a rifle. They are again complying with the most important safety rules on a shooting range or elsewhere where firearms are being discharged for obvious reasons. You heard the expert testify about the safety rules. Logic dictates that firearms cannot be discharged when someone is standing in front of the shooter. Accused number 1, like I said, was evasive. He was dishonest. He was uncredible, unreliable witness during cross-examination when he was asked to observe the clear distinguishable differences in features, size, length between the handgun and the rifle as seen in the video footage. You don't need to be a firearm expert to see that the one is much bigger in size, length than the other one. He responded that he does not know firearms. That contradicts his original evidence, how he was trained from the age of 9, how he possesses a Taurus at his home, which he had it in a safe. This clearly indicates the untruthfulness of his evidence, the unwillingness to answer, since he's the one that had both. This is the person who had both these firearms in his hand. yet he is unable to state whether the one was bigger or smaller than the other. He also attempted to downplay the issue that accused number 2 only became visible once he started shooting with a rifle. The presence of accused number 2, as I already previously stated, on the stage is problematic for accused number 1's version when the court considers the evidence of Colonel Janssen regarding what transpired when the SAPS visited Technical Security Company after the incident and were presented with SPA 249-14 and the Glock P handgun believed to have been used in this incident. No other of the other firearms were brought, and there were many. It's only these 2 firearms that were presented to believe to have been used during the commission of this offense. These 2 firearms were presented in accused number 2's presence, confirming that he knew that both these firearms were used in the commission of the offenses on the 28th of July 2022. One of them tested positive. Accused number 1 came up with the name of Mavundlo as Larry Mavundlo as an afterthought when he became aware that the rifle, according to tactical security registers, was booked out to Larry Mavundla. Even on that point, even if his version relating to how Larry was the one that we know that firearm was booked out to Larry Mavundla. We know that Larry Mavundla was in East London according to the evidence of accused number 1. As he stated that he was given this particular firearm by Larry Mavundla. But according to him, it was a toy, but when cross-examined whether he actually checked whether that was a toy or a real firearm, he said, no, if you people don't trust each other here, we work on trust. It confirms that the firearm that was handed to him was indeed the SPA 249-14, which he had fired shots. He also testified that Larry Mavundla was present in court but refused to identify him inside court. This is another indication of untruthfulness of his evidence. The court is obliged to consider all the evidence holistically when determining whether accused number 1 was a good and credible witness, as it has a direct bearing on the credibility findings of this particular court, whether accused number 1's evidence regarding the firing of blank firearms can be accepted as reasonably possibly true. You have to look at all these contradictions. The court have to look at it. It is not surprisingly that only SPA 249-14, the rifle, was linked to the spent cartridge case retrieved at the stand despite ballistic tests being conducted on several other firearms even after the brick block was changed of impact the outcome of the ballistic results. Another issue that the court has to take into consideration is the timeline of this incident. The timeline regarding when and where the cartridge case was discovered, as well as the proximity of its discovery in relation to the stage. Remember, all this is just estimations. No reconstruction of the actual scene has been done, as testified by Becker and all these other witnesses in Guadalajara. There was no reconstruction of the scene, so it's just estimations as to where the spent cartridge was found in relation to where the stage was erected. Several shots were fired by accused number 1 from 2 different caliber fire at approximately 8 o'clock the Saturday evening of 28 July 2018. In his evidence, he testified that he remained at the stadium until 2 o'clock that evening, that Sunday morning. So the incident occurred the Saturday evening. He remained there until 2 o'clock the Sunday morning, 2 o'clock. He testified Sunday morning 29, not much happened that Sunday morning other than beer house staff dismantling the stage on 29 and 30 July 2018. That's all that happened there. They were dismantling the stage in order to take it back to KZN. In the morning of 30 July 2018, an employee of BCM found the spent cartridge case on the right-hand side of the stadium in close proximity where the stage was erected, which incidentally is also the same direction where accused number 1 fired the shots. The cartridge case was positively linked to SPA rifle that resembles the same type, make, size, caliber and model as viewed in the video footage. Karim Godleka testified that live ammunition only becomes cartridge cases after shots are fired. Accused number 1 testified that he was the only one that fired shots on 28 July 2018, and this fact remains undisputed. Nobody else fired shots on that night, according to his own evidence, except him. Accused 1's version that it was a blank firearm should be rejected, as blank firearms, according to both ballistic experts, cannot shoot and fire real ammunition and cannot produce spent cartridge cases. It is admitted that the timing of producing of accused of this supposedly blank firearm by accused number 1 is circumspect and seemed like a desperate attempt to evade the truth that this rifle was never produced when both experts testified, so they could give their expert opinion in this regard. I've already said we expected at least the defense expert to testify regarding that. The court, none of us are experts relating to firearms, whether that was indeed the exact same make and model or relating to that particular firearm. Accused number 1 provided no plausible explanation how the spent cartridge was discovered at the very same stadium where he fired shots, other than to state that he does not know or that it could have been planted there before he arrived at the stadium or when he left the stadium. This court is not obliged to indulge in conjecture and find an answer to every possible inference which ingenuity may suggest, any more than the court is called upon to seek speculative explanations for conduct for which, on the face of it, is incriminating. If accused number 1 was framed as he claimed, and the spent cartridge was indeed planted at the stadium, this would mean that the person who planted it knew beforehand accused number 1 will discharge several shots with a similar rifle to the one depicted in the video footage, and someone will take a video footage of the incident, or that person planted the exact spent cartridge case which matched the rifle belonging to security company of accused number 2 and or where Laurie Mavuntla were employed. In other words, that person must have been a fortune teller, whoever wanted to plant or frame accused number 1. He must have known this was going to happen, and that's what I need to bring along in order to get him. It has been put to the witnesses by counsel that SPA 249 was in Gauteng and not in East London during the incident. It cannot be true that this version is correct, and it cannot be accepted that SPA could have been in East London to fire shots and be utilized in Gauteng simultaneously. If the court considers the timeline, which I already indicated, the Saturday evening, until 2 o'clock Sunday morning, they were at the stadium. They left. Nothing happened except gear house people dismantling the stage. And then the following morning, which is the Monday, this spent cartridge was found. Accused number 1, evidence that he was trained as an anti-apartheid activist is fiction, such as his version in this case. Accused number 1, sorry, that's a typo. If one look at how old he is, must have been 8 or 9 years old during the 1990s, and 11 years old in 1993 when the previous dispensation ended. Accused number 1 should be convicted on his own version, especially in light of the fact that Tactical Security Director confirmed that SPA was booked out to Larry Mavondla when accused number 1 testified, handed that fire rifle to him. Mavondla was indeed a blank rifle as trusted level. That was not one. Its submission is that it was indeed a real firearm as it was booked out to him. The greatest stumbling blocks, as indicated earlier, is basically the evidence, the real evidence of the video footage and the images depicted therein. If I just might deal shortly with the video footage, I see from the heads of both counsel that they still contesting the authenticity of that video footage.
Advocate Caesar, at this point, I just want to inquire from court staff. Yes, we had a late start, but it is 1:05. I'm not sure. Some have children to fetch, obligations between 1 and 2. We can possibly start sooner or earlier, but I need to accommodate all of them.
My apologies, Your Honor.
So may I just hear...
Just to say, the IT person already showed me earlier with a cell phone. I just forgot about the time that you needed to.
So I just want to know, do you want to start at 2 or shall we try and see if we can commence at 13:45? But I think everyone needs a water break and a lunch break. It's up to you. I'll be in my office so you can tell me the time. I have to add my office is twice as full as it was last time. What would you like to do at Caesar?
Maybe a 20-minute comfort break, Your Worship. I'm so sorry. Okay.
No? Okay, then I hear you. Advocate Julius.
Your Worship says I don't want to put it to 2 months. Whatever time we want to restart, but we need to take into account the stuff.
Yes, that is my concern. So I know some fetch because I work with them.
You soon thereafter, and we may call it.
Sorry?
You started calling it to you, or soon thereafter, as we may call it.
Yes, if everyone's back, is that in order if we say we can start at 2 all court staff?
Yes, Your Worship. Correct.
Is that suitable for staff? Mr. Mkumbrata? Is 2 still not? Okay, then we'll anticipate I'll enter court 2.
All right.
how to deal with disputes of facts. It is equally true that findings of credibility cannot be judged in isolation, but are required to be considered in the light of the proven facts and the probabilities of the matter. So, if you look at the Stellenbosch crime winery case, where there is a conflict of fact between the state and the defense cases, it's like in this case, the proper approach is for the court to apply its mind not only to the merits and demerits of the evidence of the state witnesses and the defense witnesses, but also to the probabilities of the case. It's very important to look at the probabilities, as probabilities play a role in both civil and criminal proceedings. Is necessarily fully revert to be summarized correct approach, as I stated in paragraph 5 of the Stellenbosch winery case. The matter was held in the SCA in paragraph 5, stated as follows: on the central issue as to what the parties actually decided, there are two irreconcilable versions. So too on the number of peripheral areas of dispute which may have a bearing on the probabilities. The technique generally employed by the courts in resolving factual disputes of this nature may conveniently be summarized as follows: to come to a conclusion on the disputed issues, a court must make a finding on, firstly, the credibility of the various factual witnesses, b, their reliability, c, the probabilities. The court's finding on the credibility of a particular witness will depend on its impression about the veracity of the witness. That in turn will depend on a variety of subsidiary factors. It's mentioned there: external contradiction, the witness conduct and demeanor in the witness box, his bias, latent and blatant, internal contradictions in his evidence, external contradictions with what was pleaded on or put on his behalf, or with established facts, or with his own extraocular statements or actions, the probability or improbability of particular aspects of his version, the caliber and contingency of his performance compared to what the other witnesses testifying about the same incident or event. A witness reliability will depend, apart from the factors mentioned under these paragraphs. It's mentioned above, the opportunities he had to experience or observe the event in question, the quality, integrity, independence, and of his recall thereof. It goes on and on. It also deals, state versus Saul is also dealing with that particular matter. It's been fully canvassed in my heads of argument. For the sake of time, I would not deal, but the Stellenbosch winery case is a very important case that the court must look at in order to decide regarding whether to acquit the accused or whether to convict him. If there's no positive proved facts from which the inference can be made, the method of inference falls, and what is left is mere speculation and conjecture. Your Worship, if I can just go to that, the action of the people that were actually present on that particular scene, and the issues, the safety features relating how and a person is trained to always keep the firearm pointed in the safe direction, away from the people, which is what has been done here by accused number 1, if you look at the video. Even the person that handed the firearm over to the accused, if you look at the 9mm, he didn't point it towards the accused. He kept it at the safe direction. Pointing towards the safe direction is then when it's handed over. You always keep your finger off the trigger until it's ready to fire. All these have been observed if you look at the video. You always treat the firearm as if it were loaded. In other words, at a 90-degree angle before it was discharged. It can be discharged. Always know the target and what is beyond it. Accused number 1, if you look at that video, he doesn't fire shots anywhere. He fires it towards the air. If you look at the video, There are submissions that it could have been, the tent should have been, or the stage should have been damaged. No, it's not correct. If you look at where exactly accused number 1 went to go fire that shot. Right to the very end, taking out his hand, pointing the firearm towards the air, and then fired shots. That submission that he would have damaged anything there, it just cannot be true if one look at the evidence. It's submitted that over and above the direct evidence implicating the accused as the perpetrator of the offense, the cumulative effect of the probabilities pointing in the same general direction may be such to establish the guilt of an accused beyond reasonable doubt. His actions must also be looked at on the day in question, how he conducted himself. It's an important factor that needed to be considered. I've referred the court previously to State versus Boza and another in 2 L.J. said the following would probably give effect to the wishes of society and the purpose of the Constitution. An innocent person must, as far possible, never be convicted of an offense. I agree completely with that submission. The conviction of a guilty person must be obtained with the best possible endeavors. The Ramaitim remains silent, and the satisfaction of the onus which is on the state must be satisfied as far as possible. It's our submission that we have satisfied the onus that was placed on us. The rights of an accused are very important. That is our submission. The right of the community to see that justice is done is equally important. To achieve these goals, instruments should be used in such a way that justice is done to everybody. It's my submission that the state has proved its case beyond reasonable doubt, and this court must distinguish the branches from the leaves in light of the totality of the evidence and reject accused number 1's version. Must look through the dust and the smoke and look at the evidence as it is. In concluding, the first principle of judging is, according to Lord Brown Wilkinson, that dirty dogs don't win. They submitted that acquitting an accused one in light of the real evidence presented in this case will bring the repute of the administration of justice into disrepute, and it will open a Pandora's box where everybody will just run around with firearms and claiming that is toy firearms. Accused 1 and 2, in my submission, you also defeated the proper administration of justice by removing. They're the only ones that could have removed. I want the court to look at that inference, remove the rest of that spent cartridge from the scene, and conspire to remove or replace the bolt assembly of the rifle SPA to affect the outcome of the ballistic results. When they realized the police had retrieved the spent cartridge case from the scene. I've said about the Carl Lewis in the state versus Jalum that a criminal trial is not a game. If accused one, if I wasn't certain about his guilt in this matter, I would have conceded such and assisted the court to acquit the accused. It's not a criminal game, and the judge's position is not merely that of an umpire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He's not merely a figurehead. He has not only to direct and control proceeding according to the recognized rules of procedure, but to see that justice is done. I submit that in the circumstances, a strong case has been made out by the state against the accused, with the evidence being supported by real evidence in respect of all the charges listed above. I will submit, Your Worship, that accused number 1 be convicted of all the charges. Alternatively, that the court look at that section 257 as a necessary after the fact. As I explained to the court, my understanding, and as it's explained in Snyman, doesn't matter what the other accused, what type of offense accused number 1 committed. If accused number 2 assisted him thereafter, he's guilty of all those type of offenses that was committed by accused number 1. In this case, we submit that he's the one that had that broke place, because coincidentally on the day when the police arrived there, this firearm apparently arrived from Port Elizabeth or from Gauteng, where it was apparently, or Johannesburg, where it was. It arrived now in KZN just as the police arrived. It's too many coincidences. Your Worship, that's basically my argument. Just one small issue that I want to deal with, Your Worship, in relating to the charges. The charges, if I've looked at my learned friend's counsel for accused number 1 argument relating to what exactly accused is being charged with, and how it looks like an attack about my inaccuracy on how I listed the charges. It is not correct, Your Worship. Accused number 1, if you look at it, at the charge sheet, it refers to, as I stated, after he's been charged, after the 2.2 Remington, my former colleague put in N.O. firearm of a caliber, of an unknown caliber, N.O. She didn't just stop there at the 2.2 Remington. It's my submission, Your Worship, that when she referred to N.O., she referred to the other firearm that was also seen on the video that discharged that particular firearm. If the submission is made that I want to adapt the evidence to suit my case, that is not correct in the acts of argument of counsel for accused number 2. I think I must just address it. The word "and" is used to connect words of the same part of a speech, clauses. That's according to Oxford Dictionary. I didn't draft the charge sheet. But she put in "and/or." She knew about the .2223 Remington rifle, and she added "and/or," used to connect words of the same part of speech, clauses, and sentences that are to be taken jointly. Its meaning of "and" used to introduce an additional comment or interjection, like bread and butter. Bread and butter, Your Worship. The accused number counsel's issue relating to that can also be dealt with section 86 from a section 84 dealing with charge sheets up to section 88 deals with that issue if there is a defect in the charge sheet. In this instance, counsel for accused number 1 given everything that was in the docket. They were given those both video footage relating to the handgun. They were given the video footages relating to the rifle. They were given possession of the video footage, the viral video footage. It's not that they've been taken by surprise about this. If they haven't prepared accused number 1 to answer on those particular video footages, it cannot be now laid on the state's door. That is my submission. The purpose of section 87 is to inform the accused of the charge, to allow and enable him to prepare a proper defense. In other words, it is to inform the accused on what evidence will be brought against him and not how the evidence will be presented. Section 84, it deals with the charge sheet. I can go on and on about it, Your Worship. And where charge sheet section 86(1) deals with whether there's a defect. In my submission, there was no defect in this particular charge sheet. Thank you, Worship. That is basically my submission.
Sorry, Advocate Otis. Advocate Caesar, on one aspect regarding your Advocate Caesar,
Yes, ma'am.
one aspect regarding your address, I would like to reply on it, and if you are not ready to reply, you may do so as per norm after. But if you are asking the court to look at the provisions of section 257
Yes, Your Worship.
of Act 51 of 1977,
Yes, Your Worship.
is it not pertinent for the state to allege that in the charge sheet prior?
Worship, if my understanding of, I stand to be corrected on that point, Your Worship. My understanding that an accused may not be charged for a particular offense on that particular nature. It is my submission that it's not really needed to be alleged in the particular charge. That's why it's drafted in that way and constructed in that way, that it doesn't matter what the other accused did, that the accused after can be convicted of an accessory after the fact.
And you also maintain that in light of the statutory offences faced by accused persons.
That's correct, Your Worship. I had to go to Snyman to understand what it meant, Your Worship, because I wanted to be accurate on that point, because that section is so confusing. It's so long, if I can put it like that. Snyman makes it clear that it's obvious the one accused would never be present if you convict him or the other one of accessory of the fact. He came in afterwards. I just need to submit that is my interpretation of it. It doesn't mean that it's an accurate interpretation.
That's why I just asked your input and clarity. I leave it at that.
Yes. Is there just one aspect that I left out? Just one. The issue about the DNA, the touch DNA that was also on their heads of argument. Your Worship, you would not find touch DNA of any of the accused in this instance. This firearm was already out of the province. Out of the province. Even accused number 2 is the one that gave or brought the firearm back for a ballistic test, and his fingerprints still were not on that firearm. So that is not an issue that shouldn't be decided. Courts have convicted the accused persons on much less evidence. If you look at section 208, if my memory serves me correctly, of just a witness, a single evidence of the single state eyewitness. Thank you.
All right, my last question, and then I'm sure the defense will elaborate on that. I think right in the beginning of the proceedings, it was mentioned that the defense for accused 2 had requested further particulars, and I recall vividly I asked you whether you were aware, because that was the first day you came on record. You said no. I assume now you are aware.
Yes, Your Worship.
But I also indicated that that request and that reply is still not part of the charge sheet before this court.
It should be.
It should be,
Yes,
but
yes.
it's not, and I do not have it to retrieve it to attach it. So maybe it's in the court file where it is headed, but no one has attached it to the charge sheet,
It should have been.
which the court has to have insight in. So I'm just placing that on record. So if need be, I would greatly appreciate having insight in the request and the reply.
Worship, I will try to find it. I've seen it in one of the files, but I'm sure counsel will have it with them.
Also,
Since I came in after.
But not there.
after the
that's-
fact.
No,
I'm
no.
sorry I don't jump off, I saw me.
Advocate Matthews, I've got broken legs, hips, arms, so I fully understand. All right, let me just get to you, Advocate Otis, just a minute.
So now approximately through
Certainly. Thank you. I'm ready to proceed.
Thank you, Worship.
Advocate Otis.
Your Worship, I'm going to start with some opening observations, if I may, and then I'll go into the argument. Firstly, I reiterate my apology for being late this morning, Your Worship, but we were told that the matter was starting at 12. But that being the case, we also didn't anticipate that we'd be required to express our view on our own heads of argument, but I think I have to follow the pattern of my learned friend. I was under the impression that the heads had been filed and that he would answer my heads, which he hadn't had an opportunity to do, and then we'd go deal with it with the argument thereafter. That having set the tone by going through his heads, I believe that I'm obliged to do that. It might be that the cameras got the better of him, and that's why we're in this position, but so be it. What I want to...
Advocate Otis,
Yes, Worship.
it's an uncalled for statement.
As Worship pleases. Worship,
mean-
I'm going to try my best to avoid those uncalled for statements, but I need to forewarn you, Worship, that issues were attributed to me that don't belong with me, and I don't take responsibility for them. He needs to, and I'll make it clear as we continue.
Sorry, I'm not being deliberate.
As
I just want to follow exactly that I understand you. May you just please repeat? You say,
Yes. Issues were attributed to me, Worship, that did not emanate from me, and for which I will be holding him accountable. It's as simple as that, Worship.
I hear what you are saying.
Thank you, Worship. So if I may begin then, Worship, it's human nature and logical that one makes a conclusion as to whether a person is guilty or not, and then in a judgment justifies that conclusion. That's why it's a common trend these days. We have it in the SCA and the Constitutional Court, where the order is given and then the ratio or the reasoning behind the order follows. So here, Your Worship, we have a similar position that one humanly and logically makes a conclusion, then justifies the conclusion with regard to the evidence, the probabilities and all other factors, in taking a holistic view to the matter. Now, there are two major issues that my learned friend might take offense with, but I need to put them up front and make myself clear. Firstly, Your Worship, we are of the view, with respect, that the charge sheet has been reverse engineered, for want of a better term, or adapted to suit the evidence, as I will show, Your Worship. And I heard what he said at the end, that his predecessor had utilized the term or euphemism and stroke or as a justification for his interpretation of the charge sheet. And I say, with respect, and I'll make it very clear in my argument, as I have that already done in my heads of argument, Your Worship, that this doesn't, with respect, cure the problem for the state. So the first issue, which is accepted as being my allegation against him, is that the charge sheet has been reverse engineered to suit the evidence that was led. I make that clearly in my head, and he's dealt with it. And his answer is that it's and or, and he used the phrase, he said, like bread and butter. Well, with respect, Your Worship, I can't give you a sandwich of bread and or butter, because if I give you bread and butter, it's got a particular meaning. Meaning if I give you bread or butter, there's no sandwich left. And that's what's going to happen to his charge sheet with respect. So he used the example now right at the end, and if you just have to apply it logically, Your Worship, to see it doesn't work. If I make an allegation, you can come to my restaurant, I'm going to give you a sandwich with bread and or butter. Sandwich implies it must be bread with butter. It cannot be the one without the other, and it cannot be the one to the exclusion of the other or in the alternative. And that's what's going to happen here. The second and most troubling, Your Worship, and let me put it up front so we can deal with it, is whilst addressing Your Worship, he said that I had come up with the concept of accused zero. Now, Your Worship, there's zero credibility to that allegation. It's a matter of logical fact, Your Worship, that he filed his heads of argument long before we did, and he refers to Larry Mavunda as accused zero. And I'm saying that there's no such concept in our law, in all my years of experience, and I even challenge Your Worship on this, to think of any matter Your Worship's heard of an accused zero. That's equivalent, Your Worship, to finding somebody in the gallery guilty of an offence that they haven't committed, and that's why I don't know where this concept comes from. I think it's absolutely foreign, and it's part and parcel of the reverse engineering to maintain that there was in fact such a position in our law or such a sustainable argument based on these facts. So those are my two major contentions, Your Worship, and I accept full responsibility for them. As he says, in my capacity as an officer of the court, I challenge anybody, Your Worship, with many, many years more than me of experience to explain the concept of accused zero. It's impossible with respect. It defies all logical explanation.
Since you used the word, you challenged the court.
Yes.
I want to ask you the following, and then I stand corrected, and I will have to revert back to the record. But the concept of accused zero emanated from your client's evidence. So I assume that is where the state got it from. But the manner in which he refers to accused zero, well, that I will address at a later stage. But that is the only time I've ever heard of it. I fully agree with you.
Thank you. Thank you. But for the record, Your Worship, my client is a layman in the law.
Sorry?
For the record, my client is a layman when it comes to the law. My learned friend is not. So, Your Worship, if I may then begin. And what we say, Your Worship, and I will have regard to the exhibits, in illustrating the point. We set out in the introduction, Your Worship, the charges that the two accused face. We distinguish between the two accused persons. And we say, accused one faces 5 of the counts and accused 2 faces only 2 of the counts. The counts all relate to an incident at the Sisa Dukasi Stadium in Datsani, which we refer to as the stadium, within this court's jurisdiction, and we all know that the purpose why all the people were there, and it's estimated in the record, Your Worship, to be some 20,000 people, were to celebrate the EFF's 5th anniversary. And we set out the charges, Your Worship, with regard to the actual charge sheet, and I have it here, Your Worship, so there can be no doubt that I'm quoting it correctly. It's inexcusable to say I never drew up the charge sheet, therefore I'm not responsible for it. It says, or my colleague drew it up and my colleague dealt with the further particulars, but I ran the trial. So and I've checked it and I find no flaws in her approach. That, Your Worship, is uncalled for in a trial of this nature. So the charges are, firstly, accused one unlawfully possessed a firearm, and it's defined, Your Worship, to wit, a .223 Norinco rifle and stroke or a firearm, the make of which is unknown to the state without holding a license, permit or authorization. That is exactly how the charge sheet reads, Your Worship.
Yes.
Count 2 is accused one unlawfully possessed ammunition, to wit, and it's there, Your Worship, the article A .223 Remington bullet, without holding a license, permit, dealer's license, manufacturer's license, goldsmith's license, import or export, or in-transit permit or authorization to do so. There's no and or that covers that situation with respect to Your Worship. It's there, and that's the charge that they were challenged to meet. And as he's just told Your Worship, a charge sheet enables an accused to prepare for the trial that they have to meet. So there we have it in count 2. It's specifically a .223 Remington bullet. Nothing about 9mm, and let me say it up front, or any other type of firearm or any other type of ammunition. It just doesn't exist there with respect to Your Worship. Count 3 was accused one unlawfully discharged a firearm, to wit, a .223 Norinco rifle and or a firearm, the make of which is unknown to the state, in the built-up area or any public place, to wit, the stadium. So let me pause at the end of all first 3 counts, Your Worship. They all refer to a firearm, not firearms in the plural. They say it's drawn, and it's meant to be drawn with precision. So it speaks of something in the singular being a firearm, a piece, an item of ammunition, or discharging a firearm, not firearms. And stroke or will never cure that with respect to your worship. It means one or the other. It's like a sandwich with bread and or butter isn't the answer, but you can have a sandwich with jam and or butter. It still has to have something inside it with respect to worship, and that's using the illustration that my learned friend used just to show how clear it is. You still have to have a sandwich. Here you have to have an item once we put a vowel in the front. Then count 4. Accused 1 and 2 unlawfully failed to take reasonable precautions to avoid danger to personal property, and that the accused both had control of a loaded firearm. Once again, your worship will see to it a, not several, a. .223 Norinco rifle and or a firearm, the make of which is unknown to the state in circumstances where it created a risk to the safety or property of the general public attending the celebration. Count 5. Accused 1 recklessly endangered a person or property in that accused 1 unlawfully discharged or handled the firearm to wit a .223 Norinco rifle and or a firearm, the make of which is unknown to the state in a manner likely to injure or endanger the safety or property of the general public attending the celebration, residents of Mdantsane and the employees of Gear House, or with reckless disregard for the safety or property of the general public attending the celebration, the residents of Mdantsane and Gear House employees. And then finally, it's only for accused 2, provided a firearm or ammunition to any person not allowed to possess it. So if we look at the counts, your worship, it's quite clear that it refers to one specific set of conduct or one specific action. It doesn't refer to firearms or ammunitions that were. It speaks of only in the singular, to put it bluntly, your worship. We then set out the plea, your worship's well aware that they both gave not guilty pleas. Accused number 1 denied the allegations against him, put the state to the proof thereof, whereas accused 2 gave a detailed plea explanation in which he denied that he had handed a firearm or ammunition as alleged in the charge sheet, read with the further particulars to accused 1. That's what the record will reflect, your worship. Now, it doesn't help to say I'm an officer of the court and I would argue for the acquittal of the accused if I didn't prove the case, but at the same time, please find him guilty as an accessory after the fact. These are the specific details of the charge, and we all know, your worship, as your worship already asked, the further particulars amend the charge so as to enable the accused to meet the case that he has to meet. Now, in contradistinction to this, your worship, in my learned friend's heads of argument, he sets out the counts as follows in his paragraph 2. Count 1, unlawful possession of a firearm. Then he does dash. Rifle and, not and stroke or. He can't hide behind what his colleague says when he sets out the different case here. So count 1 is unlawful possession of a firearm dash rifle and unknown firearm accused 1 only. That's not the case with respect to your worship. The charge sheet speaks for itself. When we cannot say it's open to interpretation, that and stroke or means it wasn't just one firearm, it's 2 or 3 or several other firearms. But that's the case that he says was made out. Secondly, your worship, in count 2, he says unlawful possession of ammunition, and all of a sudden he goes away from the definition that's given there of the Remington ammunition. He says unlawful possession of ammunition, accused 1 only. Count 3 says discharge of a firearm in a public place or built up area or any public place, accused 1 only. Once again, a firearm. Count 4, failure to take reasonable precautions to avoid danger to personal property, accused 1 and 2. Count 5, reckless endangerment to personal property, accused 1. And his count 6 is providing a firearm or ammunition to any person not allowed to possess it, accused 2. So he's, with respect, changed the goalposts in his idea of what he set out to prove and what he tells the court that he set to prove when he drew his heads of argument up after the evidence had been laid. So now, if we turn, your worship, to what we say here, the evidence. And we say, and I challenge him on this one, Your Worship, and it's not a personal attack in any way. There were 19 witnesses, not 18. Very little turns on the witness that he excluded, but the record will reflect that there were 19, not 18. I take no issue with that, Your Worship. But when we look at the testimony, and he makes this concession in his heads, when we deal with Colonel Nkwali, Colonel Nkwali says he had heard a loud noise. This is at the foot of page 3 of my head, Your Worship, but suspected that they were fireworks. He did not see accused one firing any shots on the date of the EFF celebration. He had been sent video footage that indicated that the accused one had fired shots with what appeared to be a rifle on stage. This resulted in him opening a case as the complainant, even though he had not received any report of any shooting taking place before, June, or after the event. That's conceded by him, Your Worship, in his paragraph 7.1. So if I can deal with both heads of argument at the same time, in 7.1 he says that he thought it was fireworks, and he explains that it turned out that it was shots, and that and that he didn't investigate it at the time, only once he had been shown the video footage. So we immediately ask ourselves one question, Your Worship. Did he report the matter, or is he also guilty, as my learned friend would want you to hear, of being an accessory after the fact? Because he was there and he didn't really do anything until it went viral and everybody complained about it. And this is going to be repeated several times, Your Worship. The second witness, Your Worship, was Mtombekile Menkuma. Now it's interesting to see how we heard the same evidence but deal with it differently. He says, and I'm summarizing, Your Worship, in his paragraph 7.2, that she was a cleaner and she was cleaning the stadium after the birthday celebration had taken place, and found an empty cartridge case on the right side of the stadium, and now I'm quoting from his head, Your Worship, a few meters away from where the EFF stage was erected. Nothing could be further from the truth with respect to Your Worship. Few, and my learned friend is invited to look it up in the Oxford Dictionary, depicts 2 or 3, not 10, 20, 30, 40, 50 meters. It cannot be the case. And he goes further, Your Worship, because this becomes an important aspect of his heads of argument, where he invites Your Worship to have regard to the location where this cartridge was found and to draw inferences from it. And I invite and in fact beg Your Worship to do so, because that would lead to the acquittal of the accused. And he says here, Your Worship, in 7.2, that she then, Captain Swart visited the stadium on 1 August 2018 to interview the witness regarding the discovery of the spent cartridge case. She informed him that she gave the cartridge case to the wino, who is her supervisor. She had to point out the location where the cartridge was retrieved. Sergeant Nkululeko Tuzi took photos when she pointed the place where she found the cartridge case. This photo album was handed in an exhibit. It's very vanilla, Your Worship. We're told in the first paragraph, the witness says a few meters away. So in the first paragraph of this witness, she says a few meters away, and then she says, well, have a look at the photo album. Because this was put on record, and it was depicted perfectly. What we say, Your Worship, in our paragraph 4.2 is as follows: that this lady, being a cleaner, found a spent cartridge whilst cleaning the stadium after the celebration on 30 July 2018. She handed this cartridge to a supervisor and told her friend about it. Most significantly, and once again, Your Worship, I'm taking you through the evidence like I did with the charge sheet. She pointed out the location where she had found the cartridge and was photographed doing so. And we take, Your Worship, into our confidence. And we say this photograph appears as photo 8 on exhibit A3, which is an area that is identifiable by a very high pole with lights above it on the far left-hand rear corner of the stadium, the area in front of which would have been covered by the white tent structure that appears on the photograph depicted in exhibit A. So now, Your Worship, I need to pause, because this is going to be the crux of the argument on inferences to be drawn. If we have regard, Your Worship, to what was handed in by the state as exhibit A, photograph, Your Worship, which is very important, Your Worship will see there There's the stadium as it was on the day in question. We have the light post that I'm referring to, Your Worship. As Your Worship looks at it, on the left-hand side. And we have a white tent in front of that with structures alongside it. And then we say that was Exhibit A given in by the state. And we say to Your Worship, have a look at the photo 8 on Exhibit A3. Here we have, Your Worship, the telltale sign of where the actual cartridge was found. Photograph 8 on A3 has the witness herself pointing to a spot that is at 90 I'd say 45 degrees, I beg your pardon, from the pole, but in the vicinity of that large lamppost that we see in photo 7 and photo 8. Now, Your Worship, if one talks about drawing inferences from where it was found and how it was found, it's impossible for it to have been found or to find its way there on the night in question if it was fired as the state alleges. Because one has to interpret these pictures together, Your Worship, and look at the actual evidence to say, between the stage and that lamppost, as Your Worship I'll show now, there were structures. For a cartridge to get there was absolutely impossible, taking into account the ejectile range, its common cause of the firearm that the state alleges was utilized that night. So if we have a look at these two pictures together, and I'm going to ask Your Worship in due course several times to have regard to what I'm showing now, just to realize every time he says that it was found nearby or in the vicinity, nothing could be further from the truth with respect to Your Worship, because there's a large distance between where the stage was, where the lamppost is, and to where the witness is actually pointing out. We then, Your Worship, and I can summarize it very quickly, go through the rest of the evidence. There's Nomfundo Luana, the supervisor. We've got very little debate about that. We have the next one as Captain Swart. Your Worship will remember we visited and sealed. Then we have, we call it Jonathan Kumala, he calls it Jotin Kumala. We have Lieutenant Colonel David Johannes Janssen, and he explains that they were there. And he also explained, Colonel Janssen, that Larry Mavundla, and it's in both of our heads of argument, is my paragraph 4.7, his paragraph 7.6, that Larry Mavundla was present and provided 2 further firearms for inspection, a 9mm P Glock pistol and a .223 Norinco rifle. An explanation that was given at the time, which was never disputed, was that although the firearms were not in East London on 28th of July 2018, the responsible person volunteered these firearms, as well as all other firearms in his possession for ballistic testing. His statement annexes were handed in as Exhibit C. That's the Lieutenant Colonel Janssen. He gives that explanation. So we know that they knew the explanation, and we know that he'd encountered this Larry Mavundla, who develops into accused 0. So now you've got Larry Mavundla, Your Worship, who features prominently from the outset of the investigations. And my question is a rhetorical one, because it remains unanswered, Your Worship, is what do we make of the state's failure to either charge or call this Larry Mavundla to testify? Would the court be entitled to draw negative inference? My submission, yes, definitely. Can the court infer any facts or attribute any facts to Larry Mavundla, having not called him, having had him being referred to as accused 0? My answer, Your Worship, is that is a fundamental flaw with respect in the state's case. And they were fully aware of it, and my learned friend goes further. He says, I looked at this case when I took it over from our predecessor. He's giving evidence now, but he says, and I was satisfied there's a solid case, and I accepted that it was perfect, there were no flaws in the case. That's what he said, and now we look at this, Your Worship, we say, but isn't this in itself an absolutely fundamental flaw in that Larry Mavundla was referred to from the outset, is placed on the stage, was there with all the other police officers, was the registered owner of the 2 firearms that he relies upon in his argument, but yet was never ever called to testify. We then both have Warrant Officer Becker. And then we both then have Colonel Mandisim Mgwadleka. Now, it's important, Your Worship, that I stop on Colonel Mgwadleka, because my learned friend, in his heads of argument, explains the rifles, and he says that the Colonel concluded that the breech face extractor and ejector do not correspond with the rest of the serial numbers on the firearm, and concluded it was changed to affect the outcome of the ballistic tests. He said that he was going to show Your Worship that that was admitted, but he hasn't given you the page reference, even though he said that he would. He also goes further, Your Worship, in his heads of argument at paragraph 7.9 at page 6, and he says that Mgwadleka confirmed that the markings that are made on the cartridge case by the firing pin, breech face, extractor and ejector were negative, as these parts form part of breech block that were removed after the shots were fired, but before the firearms were sent to the ballistic unit for tests. Now that, with respect, is not my recollection of his testimony. As I understood, he said there's nothing sinister to be drawn from the fact that this had been changed. And it does happen that in the process of cleaning firearms, they're often exchanged and they fit in interchangeably. I don't, with respect, believe that he said that, but that doesn't affect my argument in much. But I just want to put the record straight, if I may. We both then referred to Ashley Singh, and he calls them the Gearhouse witnesses, and I have a very similar summation of what he says about the Gearhouse witnesses. It's important that he notes that even at the stage of the Gearhouse witnesses, it was put to them and they conceded that they were unable to dispute whether the firearms were real or blank or toy firearms. That's at the foot of his paragraph 7.10. And we then deal with Samuel Ntandazo Kwata, also from Gearhouse, and Captain Mzuku. Then there's Dwayne Francis, who did the digital investigation. And then we say there was another witness. He also said there's a Captain Sorol Jacobus Kruger, who testified. We just have them in a different order, but they're there. There's Warrant Officer Amanda Yvonne Steenkamp, Captain Rian Boerter, and Captain Govender, who we make an error in referring to as a male when it was a woman. He also makes a similar error. He talks of her once as a male and once as a female. And then there's the Colonel Swartboy, who is the final person. The only witness that we say he forgot in his summation, as I said, very little turns on it, Your Worship, is we identified Captain Sorol Jacobus Kruger, who received 3 batches of firearms. Nothing turns on it, it was just in the testing process. I do not make anything of that, Your Worship. It's an absolutely innocent oversight. Now, what's important, Your Worship, and what I need to elaborate on, if I may, is in paragraph 4.19. We highlighted this, and Your Worship has heard this argument, but I need to explain it. And that's Colonel Swartboy deposed to 23 statements. He could not say whether the firearm seen in the video footage was a real firearm or a staged or blank firearm. But importantly, Your Worship, and it was he that confirmed this, because he was the investigating officer. He confirmed that 5 members of the SAPS VIP protection unit were present, and they deposed 2 statements. These statements were handed in as exhibits, but he did not make mention of any one of them seeing accused, but did not make any mention of any one of them seeing accused one firing a firearm. Why it's important, Your Worship, is he was the investigating officer. He was in charge of the docket. He'd made all these statements. He was aware, not personally involved in, but aware of these statements that were put to him when he testified, and he confirmed them. They're before the court as exhibits, and that's what's important, Your Worship. So you have now, with respect, at least 5 police officers that were on the stage, identifiable on video according to my learned friend, but were never charged as having facilitated a dangerous situation or failed to report a crime or bring accessories after the fact, or even worse, Your Worship, let me say it so that it's out there, having committed perjury, and that they were there, they saw a firearm being fired, and then deposed the affidavit saying, I never saw it, if they're in the immediate vicinity. So these are the gaps with respect that are there in the state's case. And whilst my learned friend brushes over it, another pertinent gap with respect to worship is, and it's our paragraph 5. Notably, the state was permitted to play video footage that have been spread on social media and gone viral. We refer to it as the viral footage, as well as the video footage that have been recorded by the above detailed employees of Gearhouse. We refer to that as the Gearhouse footage. The viral footage depicted the shooting, but the Gearhouse footage did not. These were accepted as exhibits by this Honourable Court. It subsequently became apparent from cross-examination that the authenticity of the viral footage had not been established, so we say that that was never established, and the laptop on which the original Gearhouse footage had been captured had been stolen. So now we have a situation, Your Worship, and it's something that the court will be required to rule on, where we have two sets of video footage. The one we have no author of, or no origin of. That's the viral one. Nobody's come and said that was my cell phone that sent that video footage. I took it. This is where I was. This is what I saw. And the authenticity was placed in dispute, has never been proven. The other, Your Worship is well aware, was on a laptop that had been stolen. So the original's missing. So it's a situation, Your Worship, where once again we have a gap in this regard. Now, my learned friend for accused number 2 has set out the different tests to be applied. My learned friend chooses the easier one for the state. That is, if it's relevant, it's admissible. It doesn't have to be the authenticity, etc. doesn't be proven. There are cases that go either way, Your Worship, out of fairness. Your Worship made a ruling at the time that it could be played, but we, at the end of the case now, Your Worship, and we haven't been able to establish the authenticity or reliability of those two videos with respect. The one lacks the actual author. We don't know who was the creator of that video. The other one, the original laptop, has been stolen on everybody's version. We then set out in our heads of argument, Your Worship, the section 174 applications, and I need with respect to repeat that because the test now is proof beyond reasonable doubt, not just whether there's a case upon which the accused ought to provide an answer in that there's a prima facie case. And we had submitted at the time on behalf of accused number 1, firstly, not one of the many eyewitnesses at the celebration complained of any firearm being discharged. So you have a situation, Worship, in summary, where you have 20,000 people in a gathering, at least 5 of whom are VIP protection officers and others. You have other policemen present, you have a whole host of people present, and not one single eyewitness who attended the event has complained of a firearm actually being discharged. Secondly, not one of the many eyewitnesses at the celebration had complained of any fear or danger due to a firearm being discharged. So nobody said that their life was in danger, or they were at risk, or they felt threatened, or that there's any danger whatsoever, which is part of the charge against the accused, endangerment. Thirdly, not one of the many eyewitnesses to the celebration had run for cover during the celebration in fear for their life or property. Now, it's all very well, my learned friend says, look at the video, look carefully, look in the corner, the extreme left-hand side, you'll see people moving away. Your Worship, that could be, they're moving to go to the toilet, they're moving to buy a bread and butter sandwich, they could be moving for any reason whatsoever. But you cannot draw the inference with respect that they're running out of fear, having not called one of them to testify. And then we say in paragraph 7.4, in fact, and most startlingly, not one attendee from the many people who had attended the celebration was called to testify as an eyewitness. Fifthly, additionally, there have been 5 SAPS VIP Protection Services members on the stage at the celebration in the stadium, and not one of them had seen or complained of any firearm being discharged. Sixthly, these 5 SAPS VIP Protection Services members had been traced and had made statements, but not one of them had mentioned anything untoward having happened at the celebration at the stadium. So not only do we hear that a firearm was fired. Police were on the stage, but they actually traced and they called to make a statement. Not one of them claims to have seen this firearm being fired or having feared anything or being scared of anybody. Seventhly, the place where the spent cartridge had been found would have been beneath structures that had been there at the time of the celebration, which made it impossible for it to have been fired from a firearm during the celebration, as the structures had been penetrated and damaged, but they had not. That's the photographs that I showed you, Worship. Eighthly, it was not possible to say when the spent cartridge had been placed there. Ninthly, it was not possible for the spent cartridge to have been ejected from a firearm on the stage at the celebration and land where it was found. And finally, Worship, there were no touch DNA traces or fingerprints to link accused one to the suspected firearm or the spent cartridge. We then say it was further submitted on behalf of accused one that the clearest indication of the deficiencies in the state's case were evident from the testimony of the investigating officer, Colonel Swartboy, who had fully investigated every aspect of this matter, been in charge of the investigation, deposed to 23 statements and testified in chief inter alia that, firstly, he had been assigned to investigate the alleged shooting at the celebration. Second, he had requested permission to interview employees and staff on duty at the time of the celebration. Thirdly, the purpose of the interviews was to establish whether they knew about the incident and to gather information about the incident. Fourthly, the scene had been reconstructed by Sergeant, subsequently Warrant Officer Becker, to ascertain where the spent cartridge had been picked up. Fifthly, he had received a copy of the viral footage that depicted accused one firing shots with, as he described, what appeared to be a firearm. Sixthly, a CD was made of the viral video footage and it was sealed in a forensic bag. Seventhly, accused one and two had been identified as having been on the stage at the celebration. Eighth, a search warrant was applied for and obtained to ascertain whether accused two had rifles in his possession that could fire that cartridge casing. Ninthly, accused two cooperated fully and assisted throughout the process. Tenthly, rifles were received in 3 batches and tested. 11thly, he was not a ballistic expert but could clearly see muzzle flash when accused one fired, as viewed on the viral video footage. 12th, one can see where the shots are being fired on the side of the stage and during the reconstruction at more or less the same area where the cartridge was found, as pointed out by the witness. And finally, the recovery of the further footage was just a confirmation of the incident together with the viral footage that was circulated. Under cross-examination, Colonel Swartboy made the following concessions. Firstly, he had not of his own accord mentioned the 5 VIP Protection Services members of the SAPS that had been on the stage at the celebration. Secondly, he had seen the statements of these officers and they had stated that they had not seen any shots being fired by accused one. Thirdly, had they seen a crime being committed in their presence, they were obliged to have reported this but had not done so. Fourthly, there was no connection by means of DNA or fingerprints between accused one and the suspected firearm. Fifthly, there was no connection by means of DNA or fingerprints between accused one and the spent cartridge. Sixthly, he had not searched the accused one's home or workplace for any such firearm. 7, no powder residue tests were conducted on the suspected firearm. 8, no eyewitnesses complained about any conduct at the celebration. 9, no eyewitnesses had been called to testify. 10th, he had not traced the photographer of the viral video footage. 11th, the chain of custody of the viral footage only began when the CD was created. 12th, he was unaware of the viral footage having been downloaded onto an external hard drive. 13th, the viral footage had never been authenticated and manipulation of it could not be excluded. 14th, the item that he had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. 15th, there had not been a reconstruction of the scene but merely a pointing out. 16th, he could not explain how the spent cartridge could have ended up where it was found. 17th, the cells and equipment had been thoroughly examined and no damage was found. 18th, he could not say whether a stage gun or blank gun had been used. And finally, he could not deny that a stage gun or blank gun emits muzzle flash. Now, I pause to add here, Your Worship, that it was clear that it was put to all of the witnesses that the accused defense was that this was a stage gun or a blank gun. Not one of them requested sight of it. Not the experts that my learned friend says were entitled to see it. Not one said, well, let me see, let me test and let me see what the case is. But it had been put from the outset, and there were security concerns, and Your Worship is well aware of it, to bring what eventually came to court when he testified through to the court. Paragraph 10. We believe that the accused was entitled to a discharge at the close of the case, and this is where we go back to the charges, Your Worship, and make our case clear. The state had not led any evidence to show that accused one possessed or shot a .223 Norinco rifle and or a firearm, the make of which is unknown to the state, without holding a license, permit or authorization. Secondly, the state had not led any evidence to show that accused one unlawfully possessed ammunition, to wit a .223 Remington bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or in-transit permit or authorization to do so. Thirdly, the state had not led any evidence to show that accused one unlawfully discharged a firearm, to wit, a .223 Norinco rifle and or a firearm the make of which is unknown to the state, in a built-up area or any public area, to wit the stadium. Fourthly, the state had not led any evidence to show that accused one unlawfully failed to take reasonable precautions to avoid danger to personal property, and that accused one had control of a loaded firearm, to wit, a .223 Norinco rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the celebration. And finally, the state had not led any evidence to show that accused one recklessly endangered a person or property, and that accused one unlawfully discharged or handled a firearm, to wit, a .223 Norinco rifle and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the celebration, residents of Ndantani and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the celebration, the residents of Ndantani and Gear House employees. So we say most significantly, accused one was not required to give evidence to supplement the state's case. Now, it's important, Your Worship, that I pause there to point out that you won't find any mention of a Glock 9mm that the state now relies upon in their submissions to Your Worship. And we record in paragraph 12 that the section 170 applications of both accused were refused, and that Your Worship delivered a judgment. And then we deal with the judgment, Your Worship. And it's important that I set out the basis, because this then sets out the case that the accused had to meet. It's in paragraph 13. Your Worship listed the witnesses that had testified and summarized their evidence. Thereafter, Your Worship addressed the issues raised in the heads of argument on behalf of accused one. In response to that, Your Worship held that even though the Gear House footage did not depict the shooting, this was cured by the evidence of the Gear House witnesses, who testified in court that they saw it afterwards but not during the event. Secondly, none of the eyewitnesses having complained come forward, run for cover, feared for their lives or property, or even testified was not relevant at that stage, but may be relevant at some point in time because they do not form part of the elements of the crimes faced by accused one. Thirdly, the 5 SAPS VIP Protection Service members who have not seen anything was also an issue that was not appropriate to raise at that time because Colonel Swartboy had only been confronted with this aspect during cross-examination. In fairness, could not answer regarding the contents of these statements because they had not been obtained by him, and these 5 witnesses had not given evidence before the court, so the court did not have a full picture of what took place as to where they were. Only they could tell, and why they were not called had left the magistrate wondering since the day she had heard so. That remains the case still today, Your Worship, with respect. Sub 4, in relation to where the cartridge had been found, which would have been underneath structures that had been there at the time of the celebrations, which then made it impossible for it to have been fired from a firearm during the celebration unless it had been penetrated and unless it had penetrated and damaged these structures. The state did not allege that the place where the cartridge had been found was the exact spot where it had been ejected. Fifthly, it was not possible to say when the spent cartridge had been placed where it had been found. It was common cause that the ejection range was 1.5 meters and 2.5 meters to the right and to the back. Sixthly, the absence of DNA or fingerprints on the cartridge was explained as that she would have been surprised if there were in fact fingerprints or DNA after some time. Seventhly, Colonel Swartwood explained that there were indeed aspects that had been concerning, and he had accepted this during cross-examination but could not clarify this under re-examination. Eighthly, Colonel Swartboy had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before He confirmed that if they had seen a crime being committed, they were duty bound to report it. Ninthly, the photographer of the viral footage had not been traced, nor had the source thereof, and the chain of custody only began when the CD was created. Tenthly, the item that Colonel Swartboy had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. 11thly, Colonel Swartboy could not deny that a stage gun or a blank gun may emit muzzle flash. 12thly, most notably, the submission that the state had not led evidence that accused one had fired a .223 Norinco firearm was not correct. And 13thly, most certainly, the court agrees that accused one is not required to give evidence to supplement the state's case. Then, in relation to accused two, Your Worship held that much emphasis was placed on the fact that none of the videos or witnesses testified that they saw him handing a firearm to accused one, but that is not the charge. The charge was unlawfully supplying or in any other manner giving possession of a firearm or ammunition, being the Norinco firearm and the Remington bullet. Paragraph 15. The court thus held that the evidence so far presented by the state required them to testify because a mere say-so that it was a movie gun does not make it so. It is not evidence. A mere say-so in light of the evidence that has been presented so far, I'm not saying which has been accepted as fact, but which has been led, I think it's led so far. Nevertheless, the state has to date not answered these issues that were raised on behalf of accused 1 and 2. So we say we're now at the end of the state's case. We are now at the end of the defense case. The onus moves to proof beyond reasonable doubt, and these troubling features still permeate every permutation of the evidence led thus far. We then explain what happened in the defense cases, and we say it was agreed between accused 1 and 2 that accused 2 would present his case first. Accused 2 called the following witnesses to testify on his behalf. First, Mr. Martin John Hood, an attorney who specialized in aspects relating to the Firearm Controls Act 60 of 2000, and he played an instrumental role in the drafting of the Act. And this is the important part that my learned friend doesn't seem to have dealt with in his heads of argument or his oral argument to Your Worship, because the important aspect of Mr. Hood's evidence as far as we were concerned is that he had assisted Tactical Security Services, TSS, to obtain its firearm licenses for their guards. And he identified the responsible person within TSS to be Clement and Luli. He had held this position since 13 March 2018. So what we say, Your Worship, is that goes against what my friend argues, that at some stage accused number 2 was an owner of the business, therefore he had an obligation, and therefore is guilty as an accessory after the fact. We say that's not the case. The responsible person for those firearms, as per the licenses, on the undisputed testimony of Mr. Hood, was this Mr. Clement and Luli. And we say that he further said that, this is Mr. Hood, explained that no license was required for a blank gun, even though they looked very similar to real firearms. He further referred to a document from Advocate Rodney de Kock of the NDPP, notifying the police that no prosecution should take place in respect of these firearms. These documents in an email were accepted as exhibits L1 and L2. They're before Your Worship. The second defense witness called by accused number 2 was Johann Christoffel de Klerk, a ballistics expert who explained his background and qualifications. He distinguished between class characteristics, subclass characteristics, and individual characteristics relating to the comparison of marks on fired cartridges. He further explained that blank guns looked the same as rifles, and that the ejection range of ammunition fired from a Norinco rifle was backwards and to the right within a 2-meter radius. So he extended a bit further than was previously the case, but it's still within that same range. Thereafter, the case for accused 2 was closed. Then accused 1 testified in his own defense and stated inter alia that he had utilized a stage gun that looked like a rifle. Now, Your Worship, let's pause here and accept my learned friend's invitation to draw inferences. So now we're not just dealing with the say-so, as Your Worship referred to it in cross-examination, but the actual under-oath testimony of the accused person. And the challenge, Your Worship, is there's nothing to disprove his version. If, by way of example, Your Worship, there had been some damage caused by a bullet nearby, then one could say he's lying because there is damage. Look what happened here. It's not the case. If the police, Your Worship, were on the stage had said there was a real gun, he's lying, then there'd be something to contradict it. If somebody else had found all these spent cartridges that my learned friend speaks of, or somebody had seen anybody picking up the spent cartridges, because now The state's version we heard today, 26 shots were fired. So yet again, another rhetorical question is going to be, well, what happened to the spent cartridges? Why is there only one when 26 shots were fired? He argues that somehow, which we don't see on video, but the inference that he asks you to draw is that accused number 2 picked up those spent cartridges. There is no evidence, not oral, not alleged, not video, of him doing so. There's no evidence of accused number 1 picking them up. He goes even further. He says there's no evidence that blank firearms, and I'll show you the quote, Your Worship, emit spent cartridges. There's no evidence to the contrary either, Your Worship. It just was never canvassed. So one spent cartridge found at a large distance under where previous structures existed with respect doesn't cure or contradict the testimony of accused number 1 when he says, I used a stage gun that looked like a rifle. One cannot say, looking at all the inferences, where it was found, when it was found, what it is, how it's traced back with possible identificatory features of being a Remington spent cartridge, etc., that would fit into a Norinco rifle. I therefore can conclude that this is the actual cartridge that came out of that firearm for all of those reasons, because it's not the case. It goes against all the other objective facts. And he says, don't just look at Rex versus Blom, look at the other cases that say, look at the conspectus of all the evidence. And if we look at the conspectus of all the evidence, then one cannot contradict that which he testified to under oath. Second, he identified such a stage gun and handed it to Your Worship and the state to see the extent to which it looked like and felt like a real rifle. Thirdly, he further explained his personal security arrangements and how his close protectors operated. He even identified them by name and subsequently pointed them out under cross-examination when the video footage was played. Fourthly, the contents of their statements was put to him, and he explained that they deposed to statements at the request of the state, not the defense. Nevertheless, they were not called by the state to testify. Fifthly, he further explained that he had brought a toy gun that he had received from the EFF Secretary General's office that had belonged to the EFF. Sixthly, he further explained that Larry Mavunda had handed it to him because it was his job to bring it there and carry it. Seventhly, he further confirmed that Larry Mavunda was present in court but refused to identify him. Eighthly, he refused to answer questions relating to a handgun because he had not faced any such charge and had prepared his defense on the charges defined by the magistrate as relating to a Norinco firearm and a Remington bullet. Ninthly, he was shown the video footage in slow motion and denied that anybody had run away in fear. Instead, he had seen people walking around and doing different things. They could not say what they appeared to be scared. In fact, they seemed to be cheering. Finally, he had never been approached to explain what firearm he had used and could have provided the blank gun for testing if he had been requested to do so. We then turned, Your Worship, to the state's heads of argument. I've dealt with some of these issues, but let's please go through them in the light of my learned friend's latest argument. We record here, and the date's important, Your Worship, that the state filed heads of argument on 12 August 2024. In those heads, the state has intentionally misconstrued the charges levelled against the accused. It now identifies the charges, and we quote from their own heads of argument, but our emphasis, Your Worship, says count 1, unlawful possession of a firearm, rifle, then in bold, and unknown firearm, accused 1 only. Count 2, unlawful possession of ammunition, accused 1 only. Count 3, discharge of a firearm in a public place or built-up area in any public place, accused 1. Count 4, failure to take reasonable precautions to avoid danger to personal property, accused 1 and 2. Count 5, reckless endangerment to personal property, accused 1 only. Count 6, providing a firearm or ammunition to any person not allowed to possess it, accused 2 only. And we say the adaptation of the charge sheet was done with the intention of attempting to adjust the charge sheet to match the evidence. This is what I referred to earlier, Your Worship, as reverse engineering. And we quote the original charge sheet, Your Worship, which I've quoted. I'll try to summarize it. Count 1 identified the firearm that was alleged to have been in accused one's possession as being a .233 Norinco rifle and or a firearm, the make of the firearm unknown to the state, without holding a license, permit or authorization issued in terms of the Firearms Control Act to possess that firearm. There is clearly an identification of the firearm that was alleged to have been possessed by accused one as being a .223 Narinka rifle, and there's reference to only one particular firearm. Count 2. Identified the ammunition that was alleged to have been in accused one's possession as being, and we quote, 1.223 Remington bullet. Without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import, export, or in-transit permit, issued in terms of the Act or otherwise authorized to do so, there is clearly an identification of the ammunition that was alleged to have been possessed by accused one as being a .233 Remington bullet, and there's reference to only one particular bullet. Count 3 identified the firearm that was alleged to have been discharged by accused one as being a .233 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, in a built-up area or any public place, to wit the Sisa Dukazi Stadium in Danzani, without good reason to do so. There is clearly an identification of the firearm that was alleged to have been discharged by accused one as being a .233 Narinka rifle, and there's reference to only one particular firearm. Additionally, the location where this is alleged to have occurred is identified as being at Sisa Dukazi Stadium in Danzani. Count 4 identified the loaded firearm that was alleged to have been under the control of accused 1 and 2 as being a .23 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the 5th Economic Freedom Fighter celebration and unlawfully failed to take precautions to avoid the danger. There is clearly an identification of the loaded firearm that was alleged to have been under the control of accused 1 and 2 as being a .233 Narinka rifle. There's reference to the general public attending the 5th Economic Freedom Fighter celebration. Count 5 identified the discharged or otherwise handled firearm that was alleged to have been discharged or otherwise handled by accused one as being a .233 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the 5th Economic Freedom Fighter celebration, residents of Danzani and the employees of Gearhouse, or with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighter celebration, the residents of Danzani and Gearhouse employees. Count 6 identified the firearm that was alleged to have been supplied or in any other manner the possession of which was passed, and the ammunition as being a .233 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, and a .223 Remington bullet. And the person to whom they were given was identified as being Julius Malema, being a person who is not allowed in terms of this act to possess that firearm and the ammunition. So we say there is clearly an identification of the firearm and the ammunition that was alleged to have been supplied by accused 2 as being a .223 Narinka rifle and the ammunition as being a .223 Remington bullet. Additionally, the person to whom accused 2 is alleged to have supplied the firearm is identified as being accused 1, and the allegation was made that he was not allowed in terms of the Firearms Control Act to possess that firearm and or ammunition. In paragraph 22, we say this intentional adaptation of the charges levelled against both accused cannot be regarded as being a bona fide error. The adaptations were made in an attempt to change the charge sheet to match the evidence that was led and to cover for some of the gaps that became evident in the state's case. The accused, in paragraph 23, both had a constitutionally recognised fundamental right to know the case they had to meet and to prepare the defences accordingly. My learned friend has conceded that today, Your Worship. Additionally, the magistrate had a duty to inform both accused what evidence was admissible against them before they presented their defence cases. We refer in regard to my learned friend's duty to section 35 of the Constitution, and for the issue relating to the admissible evidence to state this isn't law, which is in a footnote, Your Worship. We then say any attempt to now argue that the charge sheet referred to more than one firearm or more than one bullet would be prejudicial and unconstitutional. Only one firearm was referred to in the evidence of the state witnesses. This firearm was identified by them as resembling a rifle. That would be compatible with the description of it being a .223 Narinka rifle. Similarly, there is only reference to one spent cartridge in the charge sheet and the evidence of the state witnesses. This spent cartridge was identified in the charge sheet and the evidence as being a .223 Remington bullet. The adaptation by the state at this late stage is indicative of its acknowledgement that the evidence led to during the trial did not accord with the allegations in the charge sheet. This issue was alluded to by accused one who has been cross-examined by the state. He stated that he had only been charged with the possession of one particular firearm and one particular bullet. Consequently, he had prepared his defense in this trial on the basis of only those allegations as he was constitutionally entitled to do. These allegations are further borne out by the recently introduced allegation by the state in its heads of argument that a video went viral where an accused one was seen firing 15 shots with a handgun followed by an additional 7 shots with a rifle. Another clear illustration of this adaptation of the allegations against the accused is the allegation in the state's heads of argument that accused 2 is then seen approaching accused 1 after he fired the shots. Thereafter, accused 1 joined the delegates on the stage and was no longer in possession of the rifle. There can be no doubt of the clear adaptation of the allegations by virtue of the concession made by the state when it submitted. The state has not proved its case beyond reasonable doubt whether accused 2 handed the SPA 249-14 rifle to accused 1. The submission is made after proper consideration of the evidence of the third video, viral footage, coupled with the submission made in the state's further particulars, wherein it was alleged that accused 2 handed the rifle to accused 1. The video footage is inconclusive in this regard. The state has further attempted to adapt the case that it sought to make out against the accused, and it submitted that accused 2 would have been guilty of an offence in terms of section 120 sub 10 sub A if it proved that he had handed the firearm to accused 1 to commit an offence. In a further clearly prejudicial surprise move, the state has subsequently for the first time drawn the attention of this Honourable Court to the provisions of section 257 of the Criminal Procedure Act on the basis that if this Honourable Court is not in accord with the state's assessment of the evidence insofar as accused 2 is concerned, the view to encouraging this Honourable Court to convict accused 2 as an accessory after the offence. There is no justification for the state's conduct and submissions in this regard. When the witnesses, including but not limited to Mr. Hood and accused 1, testified, no such permutation or allegation was put to them. In fact, insofar as the state now seeks to contend that accused 2 facilitated the commission of an offence by accused 1, it was obliged to put that allegation to him in cross-examination but did not do so. More disturbingly, the state now submits that accused 2 had the breech block and or facilitated the removal of the breech block of the SPA 249-14 rifle to affect the outcome of the ballistic test results. We give the quote, it's paragraph 19 of the state's head, Your Worship. This was not put to any of the witnesses, including but not limited to both the state's and the defence ballistics experts. It is also not supported by any of the evidence led in the trial before this Honourable Court. Similarly, the submission that this toy blank rifle was the basis of accused 1's defence, and one would have expected that it should be produced to the ballistic expert or experts to compare it to the video footages and give an expert opinion on this aspect. In my view, the evidence relating to the actual blank toy rifle and the timing of presenting such evidence does not bolster the accused's defence, nor does it take his case anywhere. It is not only speculative, this is our submission, Your Worship, after the quote, from the heads at paragraph 29, we say it's not only speculative, but also lacks substance because the state's ballistic expert was confronted with the characteristics of such a firearm and could not dispute that it emits muzzle flash when fired. Dealing still with the heads of argument and the evaluation by my learned friend of accused 1's evidence, we say that this is unsubstantiated and we set out our reasons. Firstly, there is no substance to the allegation that he lied about seeing people running after he fired the shots, despite this factor being so obvious as people could clearly be seen running in the first video footage when he started to discharge the 9mm Glock P handgun. Secondly, there is no evidence of a 9mm Glock P handgun having been at the stadium in the possession of accused 1 or even having been discharged. Thirdly, no spent cartridges from such a firearm were found at the scene, and no damage consistent with the firing of such a firearm on numerous occasions at the scene could be found. Fourthly, in fact, it was never put to anybody who testified that such a firearm had been at the scene in the possession of accused 1 or fired by accused 1. We say in paragraph 37, in the circumstances, the allegation that accused 1 was evasive and prepared to adapt his evidence as anticipated the state's cross-examination has no substance and ought to be regarded as being more indicative of the state's conduct in this matter. The state has obviously adapted the allegations against both accused with a view to adjusting it to be consistent with the evidence led in this matter. Similarly, the allegation that accused 1 knew that these were real firearms, that firing it into the crowd would pose a serious danger to lives and limb if fired directly into the crowd is totally irreconcilable with the objective fact that no cartridges were found in the vicinity of where he was alleged to have fired these firearms and no damage could be found. Another instance of not having put allegations to accused one relates to the submission that the person that handed the firearm to accused one took it from him again after he fired the shots and pressed the slide release as the slide remained backwards when the magazine was empty, and was compelled to ensure that the slide of the firearm moved forward to its original position before he could place the firearm as his back where he originally took the firearm from before accused one fired the shots. And that's a quote, Your Worship, from the State's Heads at paragraph 32.14. This was never put to any of the witnesses who testified, including but not limited to the ballistic experts and accused one. We say, regard being had to all of the circumstances and objective facts, it cannot be contended by the State that the evidence clearly indicates that both firearms discharged were real firearms, and the court should make such a finding. And that's a quote from 32.15 of the State's Head, Your Worship. The further reference to accused 0 is nonsensical. So far as the State might wish to infer that this is a reference to Larry Mavundla, the State should provide an explanation for its failure to either call this person to testify or to have charged him for the allegation that it purports to level against accused 2. The State did not even attempt to obtain a statement from Larry Mavundla. The State's belated attempt to refer to him as accused 0 is the clearest acknowledgement of the significant role that he played, and its inexplicable failure to have approached him by virtue of this reference to him as accused 0. One wonders whether the State would not like him to have been convicted without having been tried. The most astounding submission made by the State that goes to the crux of how this Honourable Court is obliged to assess the evidence that was led before it is that the timeline regarding when and where the cartridge case was discovered, as well as the proximity of its discovery in relation to the stage, is an important aspect to consider. Due regard being had to these factors, being the time and place of discovery of the spent cartridge case, it cannot be said that there is no doubt that it was fired by accused 1 on the stage on 28 July 2018. Both the time and place of its discovery militate against a guilty verdict beyond reasonable doubt. Your Worship, we say that with regard to the photos that I showed Your Worship earlier, Exhibit A and A3, photo number 8, is seen in the context of photo number 7, and the fact, Your Worship, that there's nothing that would corroborate that. There was no powder residue test done of the accused or of his clothing or anything in that regard. We say the objective evidence and judgment by the magistrate in the Section 100 application make it clear that it has not been proved beyond a reasonable doubt that that cartridge was fired by accused 1 on 28 July 2018. This is exacerbated by the State's further contention that several shots were fired by accused 1 from 2 different caliber firearms at approximately 2000 hours the Saturday evening of 28 July 2018. It's a quote from paragraph 32.24 of his heads of argument. So surely one would have expected there to have been damage, if not injuries, and numerous spent cartridges at the site. Notably, there was no evidence by any eyewitnesses of any shooting. More significantly, there was no evidence by any eyewitness of anybody removing any spent cartridges that one would expect to have been there if accused 1 had fired several shots from 2 different caliber firearms as contended by the State. The ridiculousness of the State's submission in this regard is further borne out by its contention that the spent cartridge case was found on the right-hand side of the stadium in close proximity, and we added to where the stage was erected, which incidentally is the same direction accused 1 fired the shots. And we say, as I showed earlier, one only has to have regard to Exhibit A as viewed with photo 8 of Exhibit A3 together with the undisputed ejectile range of a Norinco rifle to dispel this myth. The maximum range can be doubled, tripled, or even quadrupled, but one will not be able to arrive at the conclusion that the State is attempting to convince this Honourable Court to make. Additionally, one would not only have expected to find injury or damage, but also numerous spent cartridges far closer to the stage, and not just one cartridge that inexplicably was found where structures had stood at the time. In fact, there is no evidence to prove that the cartridge that was handed in was actually fired on 28 July 2018. There are numerous explanations and hypotheses that can be put forward for it having been found there, but none to the exclusion of all others. To thus contend that accused 1 was the only person who fired shots on 28 July 2018 as being the sole explanation for the finding of the spent cartridge by the clean on 30 July 2018 is not sustainable. Additionally, to reject accused 1's version that he had fired a blank firearm on the basis of the spent cartridge having been found on 30 July 2018 is similarly unsustainable. To require accused one to provide a plausible explanation how the spent cartridge was discovered at the very stadium where he fired shots, other than to state that he does not know or that it could have been planted before he arrived at the stadium or when he left the stadium, is not only an unfair submission and constitutes unfair cross-examination, but does not take the case any further, make out the case of proof beyond reasonable doubt. These are quotes from the heads, or should be deemed that are identified in the footnotes. While it is submitted that this Honourable Court is not obliged to indulge in conjecture and find an answer to every possible inference which ingenuity may suggest, any more than the Court is called to seek speculative explanations for conduct for which on the face of it is incriminating, there is no legal substance to such a submission. In a similar vein, it cannot be said that once the video footage, which it is pointed out the authorship of which has not been claimed or attributed to anybody, went viral, nobody could have planted the spent cartridge at the stadium. Because Marlon and friend had argued that in order to have done that, somebody had to have planted it there knowing that this was going to go viral, but the one doesn't necessarily go before the other. It's not a logical conclusion. This Honourable Court is reminded the video footage the State refers to as the silent witness has never been proven. The objective facts are that nobody has claimed to have been the photographer of the video footage, the owner of that cellular phone has not been traced, and the laptop that was utilised by Gias was stolen and never recovered. Thus, the authenticity of the video has never been established beyond reasonable doubt. In actual fact, all of the real evidence referred to as the greatest stumbling blocks in accused one's defence that tips the scale in the State's favour are not accurately recorded in that. Let me pause here, Your Worship, to say that one can't speak of tipping the scales when proof beyond reasonable doubt is required. It's not a preponderance or a balance of probabilities. So firstly, despite the undisputed presence of thousands of people at the EFF celebration, there were no eyewitnesses who testified before this Honourable Court. Secondly, there has not been any evidence of a handgun belonging to tactical security. Thirdly, the spent cartridge was found too far away from where accused one was on the stage. Fourthly, Larry Mavunda, now referred to by the State as accused 0, has not been requested to make a statement, being called to testify or charged with any offence. This results in a negative inference being drawn against the State. And fifthly, there is nothing sinister in the reaction of accused 2 and or Larry Mavunda before, during and after the shots were fired. In fact, all the people at the stadium, both on and off the stage, appeared to be in a celebratory mood. Accused 1 explained that the celebration included an element of showmanship or surprise when he testified. He went on to explain that what had happened at other celebrations and further explained to this Honourable Court that no prior discussions relating to the stage or toy forum had taken place because this would have detracted from the elements of surprise or showmanship. Your Worship, I note it's 10 to 4. I'm going to turn to the law, whereafter I still have comments on my learned friends' heads of argument. It's unlikely that I'm going to finish today. What I would thus request is that, unless Your Worship is prepared to hear me quickly, I can try to summarise the law as quickly as possible. And then it's still for Mr. Matthews to argue. Or we can arrange a date.
Either way, we will have to come back to hear Advocate Matthews' address, so I don't want you to rush through.
Thank you, Worship. So I'll make a note here that we're going on to the onus, and if we can then arrange a date that will suit everybody with the remaining time.
Look, since it is a parted and we need to listen or hear arguments, I will leave the decision as to a suitable date to you, Advocate Hoden, Scarlett's, Advocate Caesar, because then thereafter I will be involved, but then I can accommodate.
As well. Thank you.
That's it.
My learned friends asked me about January. I do have some cancellations that arose in January. I don't know if Mr. Matthews is. I think we're going to try to arrange a date for January. I have my diary. I approach the accused.
Required the 16th, the 17th, the 23rd, and the 24th of January.
I know the 23rd and 24th is rather congested, But either way, if you are willing that or amenable to me clearing the court roll and then continuing to listen to arguments, by all means, any of those dates.
I can only do 23 and 24, Your Worship. 23 and 24.
Are you here in London on the
I'll come for this, Your Worship. I'm not in.
That's a suitable point.
23 and 24.
24, we can take both days.
You have to make certain.
And as you said already, we will wait for you to do whatever you need to do.
Yeah,
Thank
you see, the problem is in my absence, many cases were placed not by myself, so I had to work through court books and enter it in the diary. So, but nonetheless, if we can say for the 23rd, we set the time at 11 to give me an opportunity to clear the roll and see how far we get on the 23rd.
That would suit us perfectly, Your Worship, because then we can fly in on the morning of the 23rd and be here well before the
We
day.
can leave it. It's up to you.
Thank
Is
you.
that time suitable for the state advocacy?
Just want to confirm 23 and 24.
Yes.
23 and
I'll make
24,
myself
and
available.
then as from 11 on the 23rd.
No problem. Thank you.
Advocate Matthews? Please, the gallery, please. You can, I've asked kindly, sir, please. We are still in session. Accused 1 and 2. The matter then postponed for us to continue with closing arguments to the 23rd of January. We will again go back to the court we normally use, that would be Regional Court 4, trusting all is in a working condition on that date, and that we will then only start as from 11. I have an existing roll on both days, so it gives me a little bit of time to see what I can do. So 23 January, 1 and 2 on bail for address on merits to continue, and if need be, we will also continue on the 24th of January. Thank you.
That's the court business. Thank you.
I think that's how I will your worship.
Thank you. Please be seated and you may feel free to adjourn.